Good morning, everyone. Welcome back to the Joint Standing Committee on Labor and Housing. We have 3 public hearings this morning after a marathon day yesterday. So thank you, everyone, for being back and hopefully some version of well rested. We're going to start off with introductions and then we're going to jump right into our bills. Up first, I'm Senator Maddie Daughtry. I represent Senate District 24, which are the communities of Brunswick, Harpswell, Freeport, North Yarmouth, and Pownell. And I will kick it over to Senator Hickman.
Good morning, everyone. My name is Greg Hickman. I represent Senate District 14, 11 towns in Southern Kennebec County, including my hometown of Winthrop.
Thank you. And Representative Bradstreet.
Thank you and good morning. I'm Representative Dick Bradstreet. I represent House District 80, and that's my hometown of Vassalboro, Windsor, Somerville, and part of Augusta.
Thank you. Representative Cuddy.
Good morning. My name is Scott Cuddy. I represent House District 98, which is Winterport, Frankfort, Searsport, and Swanville, and I live in Winterport.
And Senator Guerin. I apologize, everyone. I'm going in the order of my Zoom boxes, which I don't know if I have not learned my lesson from Representative Drinkwater, but Senator Guerin.
Thank you very much, Madam Chair. I am Senator Stacey Guerin, representing the rural district of Senate District 10.
Thank you. And Representative Warren.
Good morning. Sophie Warren, I'm fortunate to represent part of town here in Scarborough, Maine.
Sophie, we're having a little bit of connectivity with your audio, so just keep your heads up. I don't know if it's easier with your video off, but you sounded like you've been taken by robots.
Yes, good morning. I'm Representative Sophie Warren and fortunate to be representing part of my hometown here in Scarborough, Maine. So sorry for the connection. I hope you can hear me.
Much better. Thank you so much. And Representative Geer.
Good morning. I'm Tracy Geer. I represent House District 9, which is Kennebunkport and Coastal Biddeford and Kennebunk. I'm in the car, but I will, as soon as possible, turn on my camera and get stationary. Thank you.
Of course. And just to let folks listening, a lot of us are having connectivity issues today due to the wind. So if we seem to go poof, that's the way of dealing with broadband in the state of Maine. So with that, I think we're going to get things moving. Representative Pebworth.
Thank you so much, Madam Chair. Just wanted to introduce myself. I'm Sarah Pebworth, and I'm proud to represent the towns of Blue Hill, Brooksville, Brooklyn, Castine, Sedgwick, and Surrey.
Thank you so much, Representative Pebworth. And I apologize for clearly not having enough coffee this morning. So now we're going to jump into our public hearings. Just as a reminder, this is a chance for us to solicit feedback from the public and hear from the sponsors on the proposed measures of legislation. Just a reminder that, this is a time for questioning. And if you have any questions today on the process, we're ably assisted by our lovely committee clerk, Justin Purvis, as well as our incredible OPLA analyst, Stephen Langland. So with that, I'm going to move over Senator Jackson, promote him to a panelist. And then once he's been able to rejoin us, I will kick things off. Okay, he's been able to come through the wormhole. I see Senate President Jackson there. So with that, I'm going to open the public hearing on LD 1724, an act to create a logging dispute resolution board and to require proof of ownership documents available within 14 days of request. And I will kick it over to Senator Jackson. The floor is yours.
Thank you, Senator Daughtry. Representative Sylvester and esteemed members of the Joint Standing Committee on Labor and Housing. My name is Troy Jackson, and I have the honor of representing the good people of Northern Mercer County in Senate District 1 and the privilege of serving as Senate President of the state of Maine. I'm here today to introduce LD 1724, an act to create a logging dispute resolution board and require proof of ownership documents to be available within 14 days of request. For generations, Mainers in Mercer County and rural parts of the state have worked hard to make a good living in natural resource-based industries. These heritage industries, from farming to forestry, continue to power our communities and economy today. As a fifth-generation logger, I know that the forest products industry has evolved dramatically to embrace new technology and capture new markets. However, one thing remains the same. No matter the price of the wood or the demand in the market, logging contractors have limited options when it comes to contract violations. That's why I introduced legislation to create a logging dispute resolution board. When an employer violates a contract or a workplace policy, a regular employee has a number of options for filing some sort of grievance against their employer. However, the only way a logging contractor can file a grievance against a landowner is to sue that landowner in court. For ordinary working class people, this really isn't an option. To put it simply, it requires a whole lot of time and money that most folks don't have, and it's a huge risk. The logging contractor who takes a landowner to court over a breach of a contract will likely never work in that industry again, most likely at least that landowner. Instead, they'll spend a lot of money on a lawyer, if they can even find one in the area, to go up against a large corporation's team of lawyers over a lawsuit that could get dragged out in court. This is a system that is designed to fail. Main landowners and logging contractors deserve to know that when either party signs a contract, they are signing an agreement that can be enforced. It's not a guide or a suggestion. It's a legal document that both parties must abide by. The logging dispute board is necessary to ensure that these contractors are fairly enforced, especially as issues come up related to market imperfections. One example includes concentrated land ownership in geographic locations that are remote and difficult to regulate. The logging dispute board would hear disputes regarding the hiring of contractors, contract violations, and fair payout for those contractors, especially those concerning rate setting and timely payment. This board would include a representative from the Maine Forest Products Council. And I did not ask the Forest Products Council, but I thought that they should be on one side of it for fairness. A logging contractor or an individual with arbitration experience and a member of the State Board of Arbitration and Conciliation to ensure fairness and equity. The board would operate independently with the Department of Labor and assist with the oversight of the department's industry standards and laws. As it stands, there's a really gross imbalance of power within the logging industry, where logging contractors have to accept the status quo, which includes contract violations, in order to earn a living to provide for their families. Logging contractors have to accept breaches of contract and other contract violations, or risk putting a target on their back. It makes most people feel like they are doing something wrong by simply asking a large landowner to abide by the previously agreed upon contract. The Logging Dispute Board will right this wrong and ensure that these contracts are enforced fairly for both logging contractors and large landowners. This bill also deals with Section 872, the proof of ownership notification. When this original section of statute became law, proof of ownership, the form supplied by the Maine DOL, which is required to be kept within the equipment, was to be shown upon request. Later, when a new administration came to power, the law was amended to 30 days. I think this is far from reasonable, and actually we've seen some violations of this just recently. Therefore, in the spirit of compromise, I propose a 2-week delay in case of mistake or oversight. That is more than fair. The same logic holds regarding notification of the Maine DOL regarding the employment of a bonded worker. When the law was originally conceived, the notification was to be given within 3 days of filing. This seemed reasonable at the time, but it too was amended to 30 days. So again, in the spirit of compromise, I ask you to support a 2-week lapse in the notification of bonded worker. This gives that employer ample time and secures notification that is necessary for the Maine DOL to do its job. The significance of the logging industry in Maine cannot be overstated. It's an industry that is an important part of the state's economy. It isn't easy work, but it wouldn't be possible without the hardworking logging contractors who cut and haul wood in the harshest of conditions. The power imbalance has always existed, but it's gotten worse over time. And this bill offers a simple way to ensure fairness and justice in this vital industry for everyone. I want to say that I've said this probably 1,000 times, but in 1992, or around that area, my father was an actual employee, and my father owned trucks most all his life. And as an employee of the landowners, he was given a check for his hourly wages, and those hourly wages were had Social Security, had unemployment, had workers' comp on those, had everything that an employee and employer relationship has. But at the same time, he also was paid another check where that check gave him his truck's wages. And he was an employee of the landowner. And that system existed, like I said, right up until at least 92. I mean, my father at that time had a 1987 Peterbilt truck with a trailer, and he hauled for different landowners across the northern Maine. And then overnight, he became an independent contractor, not at his behest, but because that's how the landowners wanted the system. Same truck, same job, same driver, went from being independent or being an employee to an independent contractor. And that, in my opinion, is why it's been so hard for logging contractors to have a fair shake in this. There really isn't any rules to protect them, and it goes on every day. I've experienced it myself, times whenever I was owed $2,500, $3,000, and you have to figure out, is it worth it? Is it worth it to hire a lawyer and go to court and take on some of these big people for what is $3,000, $5,000, maybe $10,000, maybe more? But the reality is that you'll spend all your time and money chasing this, and at the end you may win, but you didn't really win anything. You didn't make anything because you spent it all in the court case, and you've put a huge target on your back. And I deal with people every day that has to go through with this. I mean, this bill was something that a logging contractor in my area asked me to put in because he was tired of constantly having to fight for what he knew was a fair amount of work that he did. And I deal with it all the time. Representative Cuddy was in Fort Kent this weekend. I had a gentleman that was talking to me at a place that we were frequenting after the Can-Am about this. You know, it's a huge deal of logging contractors not having really any opportunity to push back against the unfairness in the industry. And I'm a little surprised, maybe more frustrated that this has gotten turned into something different. At no time, and please be clear, whenever people are speaking after me, please be clear that there was no time that this bill was supposed to be for employees to go up against logging contractors. That is not, there is avenues for that. I don't think they're very strong, but there is avenues for that currently. This was completely a logging contractor bill to bring their issues forward. In no time should anyone say that it was something different than that, or, you know, at any time should it be amended for that. I also wanted to talk a little bit about what I'm hearing, that, you know, this can't happen, that it's not legal for independent contractors to talk about price, or for a board to be set up like this to talk about price, which is absolutely incorrect. As many of you know, that we're here in the 129th legislature, that we're on this committee. We actually did take up the bill and passed it, and the governor signed it, saying that there is a federal exemption to the antitrust laws, that here in Maine, much like in the fishing industry, loggers can collectively bargain together. The legislature assumed that there was such a market imbalance in the state that we use the federal antitrust laws to give them the exemption for independent contractors to collectively bargain together. Today, there's no one that can say that they were violating the law if two logging contractors talk about price with landowners. And I've had people testify to that, or at least bring that up in regards to this bill. I've been in other meetings where people have thrown that out, and it is absolutely not the case. In Maine, it is legal It's still frowned upon by the landowners, but it's still legal. Also, one of the things that I heard yesterday was that you can't use the State Board of Arbitration to do something like this. And I just want to, I believe we're going to send it forward to you, but in fact, we actually have done this before. In 2003, a bill that was sponsored by House Chair William Smith and Van Buren, LD 1318. There's a bill that was in effect for 6 years. It almost exactly the same type of concept. The only thing is that in this bill, we're using logging contractors instead of an organization that represents labor. So the State Board of Arbitration can do this. I mean, the language is almost exact to what I'm proposing today. In fact, that's where I actually got it from. I got the idea from. And so for anyone to say that the State Board of Arbitration couldn't do that, well, we did it for 6 years, and Governor Baldacci and I think the current Labor Commissioner supported it back then at that time. The last, well, actually, it's not the last thing. You know, last session, I had this bill last session at the beginning of the year, and I shelved it because Representative O'Neill was going forward with a bill to create a forest advisory council where issues like this could be talked about in an open forum. People could actually make or have discussions about problems that were in the industry, and it was worked against vehemently that there should be a place where logging contractors could come forward and talk about the problems that they were seeing in the industry in a place that they could feel like, at least because it was out in the daylight, maybe they wouldn't be targeted or blackballed because, you know, everyone could see there was a public forum on this. Obviously, we passed that bill, and Governor Mills unfortunately vetoed it. But the same issues are in front of us today. I mean, things like the 14-day rule. Many of you don't know maybe that, but that was actually worked on by a group of people from my area before I ever got in the legislature that came down here and spent days and days and days pushing back against these same people today to get a rule that after 14 days, if your wood was sitting somewhere drying, that you could get a state scaler to come out and scale your wood and get that price, whatever the scale was. Because that's a major issue that happens where wood just sits and you don't get paid for it, and it sits there and dries up. And if you talk to the Department of Ag, that rule has not been used for 30 some years or more because no one dares to use it. No one dares to bring it forward. Because again, once you do that, you're going to put yourself in a tough spot. I also passed the bill when I was chair of Ag. Senator Hickman probably remembers. It was so insane that the bill actually said that in the case that you as a logging contractor wanted to know what you were getting paid before you did the job, the landowner had to tell you. Now that seems like a pretty simple thing for anyone, that if you wanted to know what the contract price was to haul a load from one point to another, they had to tell you. And they fought that tooth and nail. I mean, Jim Irvin actually came down and with his entourage and asked me point blank not to support it. Now, you know, when stuff like that happens, you have to look at it and say that there's something wrong with the industry. Something wrong with logging contractors not being able to get a fair shake or not even be able to be told what they want or what they're getting for a rate. So I think the last thing I want to say on this is that, you know, on Friday, I think at least one of the contractors that's going to be speaking here today in opposition to this was working on a state lot. I found out from some of the logging contractors in my area that they were using bonded workers to haul wood off the state lot. This state lot is about 20 miles from my house. It's not the remote place that you would think it is. Unfortunately, we did have a written rule in effect that said that you couldn't do that, that Mainers should get those opportunities on state grounds. That's another perfect example of something that's going on. Unfortunately, 2018, unbeknownst to me, that language is taken out of the contracts. Yesterday, the Department of Conservation called me, said that they had found that out. They were surprised to hear that. They didn't like it. They still wanted to continue with the policy, but they didn't know if they could. So I would propose that, I'll come back with an amendment to give this committee in a different way to put that back into statute. But there's a perfect example of a problem that's happening in this industry of contractors not getting the opportunities here in Maine. And another reason why I think a logging dispute board would be important for them to have an opportunity. Doesn't mean they're going to use it. Maybe like the 14-day rule, maybe it goes unused. But I think in this case here, somebody could be appointed on the logging side that understands contract issues, understands the cases that are happening out there, but maybe isn't a contractor and maybe doesn't have to worry about the target on his back or getting on the line and getting hammered because they say something that the industry doesn't like. That's what my hope is, a contract board with somebody on there that understands what it's going to take to push back on this industry and is not afraid to do it.
Thank you so much, Senate President Jackson. I have a question from Representative Cuddy.
Thank you very much, Madam Chair, and thank you very much, President Jackson, for bringing this bill forward to our committee today. The first question I have is you talked about sort of winning and losing in court, and it sounds to me from the way you've laid it out that if a logging contractor goes to court to try to get what they're due, winning would only mean that you're getting what the fair price you were promised in the first place. So now you've had to lay out funds for legal costs just to get what you thought you were going to get in the first place. Have I got that correct?
Yeah, well, that's exactly the point. I mean, you have to calculate if your losses are enough to go after that you actually really make anything out of. I mean, anything, probably under $5,000 is you're just going to have to probably chalk up as a loss because by the time you go to court, the court filing, all those things, and the 40% that a lawyer is going to take, it's really not worth it in the end. If you can get a lawyer to take it at that rate, I'm sure many of them would take it by the hour, but then you have even less time to actually make your case at that point. And that's the reality of it. And I've dealt with it. I could tell you the contractors, the people, the landowners that in the past I've lost money to, and I had to just, let it go because there just wasn't any way that I was going to recoup that going down a law court road. That's why I think it's important that much like, we do protect in this state other occupations. I mean, this is an occupation. It's a different model, but I think that there's a way that we can do this that is fair. And I wrote in the bill also that if you lose, you pay the cost of the arbitration. I think that helps stop any frivolous or cases that shouldn't go forward because obviously if you lose, you're going to pay for it. And I don't know that it's going to be that often that it will be used. A couple times to reset the goalposts in this industry, I think would be helpful. But anyways, to answer your question.
Thank you.
I have a question from Representative Bradstreet next.
Thank you, Madam Chair. First of all, I'd like to state that I have a very unstable internet connection again this morning. It was fine yesterday, not today. So I'm only catching most of what Senator Jackson is saying. So if I ask something that you probably answer, I apologize for that. First, the second member of the proposed dispute resolution board, could you tell me again who that is? I think I got the first one and the third one, but not the second one.
Well, just so I'll have all three representatives. I mean, the first one would be a member of the Maine Forest Products Council.
Right.
See that as the landowner side. The second one would be a logging contractor or their representative that has, dispute resolution, arbitration experience. I mean, that could be something that would be picked to have that. And I think personally, that would be the best way to go. Again, for the reasons I said, that, they don't have to worry about losing a contract or losing any opportunity. I mean, their job is probably more as a lawyer. And the other one would be the neutral, a member of the State Board of Arbitration, which is a understood position. And there's a list of them that does, things like this as far as arbitrating.
Okay, so the second one, it says on the original bill, New England Loggers Cooperative or a successor organization, is that the one then that would remain?
No, we did an amendment that it would be someone picked by the AFL-CIO because they do a lot already in workers' comp and stuff like that. That's a understood position, but it should be very clear that it's either a logging contractor that's picked or someone that is got arbitration and dispute resolution experience. That I feel strongly about should be the person that be picked, should have those qualities.
Okay, so that's changed. That's your reasoning behind that. Okay.
Yeah.
This proposed dispute resolution board, do you know of any other industries in the Maine that has one similar to this? And are there not already things such as the Maine Labor Relations Board, the Workers' Compensation Board, etc., who can handle dispute resolutions on certain things?
I don't. I mean, I'm a Mainer. This is where I'm from. So I don't know any other state that has used an exemption under federal antitrust law to allow logging contractors to collectively bargain together either. I think that's just the problem with our industry here in Maine. I mean, I say it all the time, 50 or more years of these things come into the legislature with the same people sitting around the same table making decisions and expecting things to be different. And they're not. I mean, this past summer, the price of softwood lumber was at an unbelievable all-time high. And still the people that work in the industry, the actual logging contractors, had more struggles than ever. And that was before the price of fuel and everything went up. This was, they're just not sharing in the profits. And the equipment that they pay for and stuff like that. I mean, I could go into that chapter and verse, but I don't know another state that does anything like this. But I honestly don't know another state that's as screwed up as this one either, as far as the logging industry.
Thank you. I have a question from Senator Guerin, followed by Representative.
Thank you, Madam Chair, and welcome to our committee, Mr. President. Just to follow up on one of Dick's questions, who is the president now of the New England Loggers Cooperative? Do you know?
I do. I am, and I'm not listed in the bill. That's why we put the AFL, but that shouldn't really make a difference. But if you want to, that's fine.
Who did you work with for in-state contractors on crafting this bill, or who was supporting it?
Well, many of the people that work in or are in the New England Loggers Cooperative, but many of my constituents, Senator Guerin, and I'm sorry, but I'm not going to list them here.
You have nobody that would put their name on it?
I would probably have some people that might put their name on it, but I'm not going to do that to them. Okay. For the very reasons that I just experienced or told you about, as far as for people being targeted and things like that. You said in a room last session, 129th, and had 25 or 30 contractors come down from Northern Maine and talk about collective bargaining and wanting that and all that, and still you voted against it. So I don't know what would do me any good to bring people down and put themselves in that position once again.
Thank you.
Definitely want to keep focus on the bill in front of us, and I do have more folks in the queue. Representative Gear, followed by Senator Hickman.
Thank you, Madam Chair, and thanks for bringing this bill, President Jackson. I'm curious about whether loggers meet the strict definition of independent contractors versus employees as set out by the IRS. And and I'm also then curious as to how many landowners a logger might typically contract with.
As far as your first question, I mean, I think that's a major debate that many people go forward with. Unfortunately, I think the industry is split on if they want to go make the argument that they are actually employees or if they are actually contractors. Like I said, you know, all the men that I knew that were in my father's, you know, working age and stuff like that were employees. They all own cable skidders. They all own trucks, and they were turned into independent contractors. Now today, most of the people that work in the industry really don't know any other way. They've always understood it to be a contractor industry. But, you know, the idea that, well, you know, in some of these contracts, not knowing what the rate that you're being paid, that would certainly suggest that you're being controlled at all times, which means that you'd be an employee. But, you know, I've thought about this a lot, thought about dealing with it in the past. I don't really know that there's any way that we're ever going to get the federal government to actually rule one way or the other in a positive light on that. So that's why I'm trying a different route with the contractor model.
And how many landowners does a logger typically might a logger typically work with?
Well, there's a whole bunch of them that only can work with one. You know, if you don't, they have a system, a performa system, and if you don't put the required hours in, you don't get the higher rate. And you know, working for another landowner throws that off for you. There is some that can work for multiple landowners, things like that, but it is certainly more challenging to go for another landowner, just frowned upon.
Thank you.
Senator Hickman.
Thank you, Madam Chair. Thank you, President Jackson, for presenting the bill. Has there ever been any historical law such as this to provide the protections that you are seeking with this bill, Mr. President?
Well, like I said, the 2003 law, LD 1318, was the first time that we put in statute something to allow independent contractors to collectively bargain together. And in that law was the language that I provided you about the State Board of Arbitration being the 3-person panel that would do the rate settings, which is, you know, a major problem, not being able to stick together to figure out or get a higher enough rate. That law was in effect for 5 years, and a whole bunch of things changed up in my area. Super contractors were brought in that were basically poster boys for some of the large landowners, and you know, agreed to not go forward with rate setting or anything like that. But still, it was problematic for at least one large landowner. And in 2008, and you can look this up, you know, Bangor Daily, we were told that if we didn't repeal the law, that the Pinkham mill just outside Ashland would close. And so we actually brought the contractors together in northern Maine and talked to them about it and had a vote on it. And they agreed to repeal the law. And so we begrudgingly repealed it in 2008. and then the Pinkham Mill closed anyways.
How soon after the law was repealed?
That same year.
Same year. Thank you.
Do I have any other questions from the committee? Seeing none, thank you so much for your time this morning, Senator Jackson. And we're going to move on to testimony. But before we do, I want to make sure we give a chance to let committee members who came in after introductions to give them a chance to introduce themselves. So Representative Rader, if you wouldn't mind introducing yourself.
Hi, I'm Representative Amy Rader. I represent District 125, which is a portion of Bangor.
And then I was also remiss in reminding folks that we will be running a 3-minute timer today for members of the public testifying. Representative Rader will be doing first on shift, but we're all a little bit tired from yesterday, so please be patient with us. And if anyone else feels like being a timer, please let us know so everyone can have a break and we can rotate it around. Just as a reminder, whomever's timing will hold it up so you can see that the timer's starting, and then we'll give you a warning and then jump in when your 3 minutes are up. With that, Senator Hickman, did you have your hand up just as a leftover? Okay. So with that, we're going to jump to folks, just as a reminder, speaking for, those speaking against, and those speaking neither for nor against. So up first, we have Jack McKay. Jack, I am porting you over. And after Jack, we will be having Jason Shedlock. So Jason, you're on deck. Jack, the floor is yours and welcome.
Good morning, thank you. Okay, great. So my name is Jack McKay, and I am here as president of the Eastern Maine Labor Council. We have 34 affiliated unions representing just over 5,000 workers in Eastern Maine, and also director of Food and Medicine, which is an organization based out of Brewer that works on food access, healthy food access, worker rights, and public transportation. Both organizations, I'm speaking on behalf of both organizations, they strongly support LB 1724 for a variety of reasons. We've been, listening to workers. We've both been, Food and Medicine has been around for 20 years, and I've heard from loggers over the years who, as independent contractors, suffer due to the unbalanced playing field, much of which you've already heard Senate President Jackson talk about. But having the large capital outlays, for their equipment and whatnot, they suffer really a disadvantaged position negotiating with large landowners such as Irving. And at times they're forced to compete with Canadians who are subsidized. And that really creates an unbalanced playing field. As Senator Jackson already said, having a lawsuit is a time-intensive and expensive process, and is not a very effective way to gain, justice. And it also invites the logger to be blacklisted, and that's a real threat. And such a blacklisting would, affect their whole way of life, especially considering, what are other options in the northern parts of Maine for, a career. The dispute panel is, we believe, is a fair way to hopefully address this situation. As Senate President said, frivolous complaints will be weeded out due to the factor of cost. And just want to underscore that independent contractors lose the labor law, whatever it is that employees gain. And this measure, we believe, would be a small yet significant step to make the playing field much more balanced. Thank you, and I'll be happy to answer any questions if you may have some.
Thank you so much. Do I have any questions from the committee at this time? Seeing none, you were a model student for getting it in under 3 minutes, so thank you.
Thank you.
Up next, we have Jason Shedlock. Jason, I'm promoting you over and popping Jack back through the wormhole. And Jason, the floor is yours and welcome.
Thank you very much, and good morning. And hopefully everybody got a little bit of rest from yesterday. Good morning, Senator Daughtry, Representative Sylvester, who I hope is well, and members of the Committee on Labor and Housing. My name is Jason J. Shedlock, and I'm a regional organizer for Laborers International Union and president of the Maine State Building and Construction Trades Council. I'm also a trustee and executive board member of both the Maine AFL-CIO and Southern Maine Labor Council, as well as serve on the Maine Apprenticeship Council and the State Workforce Board. I appear before you today in support of LD 1724, an act to create a logging dispute board and to require proof of ownership documents to be available within 14 days of request. You know, truthfully, I wasn't going to testify on this bill this morning, but as I sit here and read over the testimony of those speaking against, it occurs to me that I've seen this movie before. So I'm compelled to speak up in solidarity. We see wealthy employers pit workers against each other all the time. And that's exactly what's happening here. But instead of wealthy employers, it's wealthy landowners. Meet the new boss, same as the old boss, I suppose. I urge committee members to not overthink this. This bill is a simple concept. It's a body to give people a place to go when there are disputes. If there's not a problem, it won't be used. It reminds me of when I've testified before this committee countless times on safety requirements in the construction industry, and my friends in the industry inexplicably against them every time. If they follow the rules, they shouldn't have anything to worry about. In this case, the board shouldn't be very busy if those involved are following the rules. The general takeaway from the opposition to this bill would be that the process this bill would put in place would be rather inconvenient. I bet. The committee should consider why that would be the case. I urge you to work with the sponsor to make any necessary changes based on the constructive testimony and move forward with an ought to pass vote. Thank you very much.
Thank you so much. Do I have any questions for Mr. Shedlock from the committee? Representative Gear.
Thank you, Madam Chair. And nice to see you so soon again, Mr. Shedlock.
Thank you.
I'm always fascinated, having been involved in several industries that have had this, different kind of approach regarding employees and independent contractors. And there have been many, many long legal battles about how employees are defined as employees and how independent contractors are defined as independent contractors. It strikes me that in this case, I just would be interested in your response here, that if loggers are really only working for one landowner, and that landowner is basically directing them where and when to haul wood from, that's pretty much the job of an employee. They're being told what to do when, and they are working for one entity. And in that case, if they are, for whatever reason, being classified as independent contractors, I would just be interested in your perspective as to, should they be entitled to the same protections as employees? And is this the best way to go about doing that?
Yeah, I mean, I think that's a good question. And obviously, I think, those in the Department of Labor, I think can answer that a little bit better. To me, when you're being directed, by a singular entity, whether that's, being told how to use equipment, being told when and where to be, when you're a captive audience, so to speak, it's a pretty difficult sell to say that you're an independent contractor. You need to be provided with the proper safety equipment. You need to be sort of, you're under the employ of that person. You could split hairs and, try to drive through loopholes. But so when you're talking about having a place to go to hear disputes, at the end of the day, these workers are workers in the state of Maine. Whether they work as an independent contractor or whether they work for an employer, these are human beings that are showing up to go to work. They're getting paid to go to work, and they need the protections that entails. So, I think in this case, that there's a body for these workers to go to be able to discuss, different disputes, and I think there are different classifications of that. Seems reasonable, and I think reasonable minds can disagree about what types of disputes and how that process can play out. And I think this committee can obviously work through what that should look like with the with the sponsor, who, by the way, knows a little bit about this issue. So, I think it's important to be able to hear that and to work with constructive feedback from folks. But I think, the doth protest too much from some folks in this testimony, as you'll hear move forward. I think that should be a concern of the committee.
Thank you.
Thank you so much, Mr. Shedlock. And before, are there any other questions from the committee? Seeing none, I do just want to warn folks, I'm hearing about internet outages all over the town of Brunswick. So if I do disappear, I just want to let folks know I'll try to get back in. And Senator Hickman, if I do disappear, you're on deck. But fingers crossed that downtown Brunswick is solid on the internet front. But with that, seeing no further questions, thank you so much, Mr. Shedlock, for joining us. And up next, we have Tim Suter. Please let me know if I'm saying your name wrong. Okay. And Tim is with us. Tim, the floor is yours.
Thank you.
Welcome.
Senator Daughtry, members of the Labor and Housing Committee, thank you and good morning. I'm Tim Suter. I live in Topsom and I'm a representative of the Machinists Union. I have worked with the New England Loggers Cooperative. I am speaking in favor of LD 1724. This bill seeks to establish the Logging Dispute Resolution Board in an industry that has been ruled by one side without any enforcement in regards to violations of contracts. Too many times, independent contractors are left holding the bag with no resolution, with the only way to pursue contract violations being through an overburdened court system. A choice in which they stand to lose work by being ostracized for trying to seek basic fairness in upholding their contract, not to mention the lengthy court battle over an issue in which they have already bared the burden for. It's a no-win situation for independent contractors trying to make a living. The board, as proposed in LD 1724, would have representatives representing both sides with a neutral member of the Board of Arbitration and Conciliation. This board could resolve issues in a more efficient manner for all parties involved. Unlike employer-employee relations, where the Department of Labor Wage and Hour Division has jurisdiction to settle the disputes, independent contractors have no legitimate way to seek resolutions for violations. That is why I support LD 1724. Thank you.
Thank you so much. Do I have any questions from the committee? Seeing none, thank you so much for your time this morning and once again setting an excellent example of under 3 minutes testimony.
Thank you so much.
Up next, and the last one we have in favor is BJ McAllister. If you are in the attendees portion and you had intended to testify in favor of this bill, if you could please raise your hand or let us know in the chat so we can port you over. And with that, Mr. McAllister, the floor is yours.
Thank you, Senator Daughtry and members of the Joint Standing Committee on Labor and Housing. I first must apologize. You might hear the wind hitting the storm windows. They're doing their job, so it's a little noisy in here. My name is BJ McAllister. I'm the founder of the Resurgam Group, and I'm here today to testify on behalf of my client, the Maine AFL-CIO. We represent 40,000 working men and women across the state of Maine and work to improve the lives and working conditions of our members and all working people. Logging contractors, as you've heard, work extremely long hours, often for low pay and no benefits for large, powerful timber corporations who profit from their labor. It's no secret that logging is one of the most difficult and dangerous occupations in America. All the while, they're met with long-standing power imbalance in the industry that forces logging contractors to accept unfair contract rates for their services. At this point, the scales are not equal. Instead, they're heavily tilted towards landowners. 95% of Maine's forest is privately owned and 61% of it owned by private companies. This gives a lot of authority to landowners over the roughly 24,000 workers in an industry that annually contributes $1.8 billion to Maine's economy. These large landowners exert tremendous power over wood workers, dictating when and how much wood is cut. At this point, logging contractors have very little place to go to address these concerns. The ability of one employer to use fear and division to create a race to the bottom where isolated workers are forced to accept long hours and dangerous working conditions in exchange for low pay and minimal benefits is real. The creation of a logging dispute resolution board to hear disputes related to the logging industry, whether it's disputes regarding pay violations, payout amounts, contract violations, or a hiring dispute, helps level the playing field, plain and simple. This balanced board allows workers, contractors, landowners, and equal arbitrator to come together to settle disputes. It's a proven model that we've seen work on the state arbitration board. For too long, loggers and contractors have been taken advantage of by large landowners, and this bill will level the playing field. We ask you to support LD 1724, and I'd be happy to take any questions.
Thank you so much, Mr. McAllister. Do I have any questions from the committee? Representative Bradstreet.
Thank you, Madam Chair. Thank you, Mr. McAllister, for being here. You mentioned that there seems to be an uneven playing field. That, as I understand it, the current setup is that there are a number of ways a person can bring a dispute before a board, such as the National Maine Labor Relations Board. There's OSHA, things of that sort. So in your opinion, why would another entity, such as a proposed dispute resolution board, be any different if it is an unbiased board?
Thank you for the question, Representative. In our opinion, this board would create a more equal playing field because it would be players within the industry that it's looking to respond to would be involved. I mean, for example, OSHA can't directly deal with wage issues, but also OSHA doesn't necessarily have somebody who's on both sides of this logging imbalance that we talk about in this bill. So I think the other thing that I would say, and it's been said before, if this board is established and it's not used, that's one thing. But if this board is established and it's used even by two people, this committee can know that they played a role in leveling a playing field that is currently not level. So we believe that having more outlets for people to be involved and level a playing field is valuable.
Thank you so much. Do I have any further questions from the committee at this time? Seeing none, thank you so much for your testimony.
Thank you all.
Up next, I don't see any hands going up for in favor. We're going to be switching to in opposition. On the list, I am not seeing them with us. I had Aaron Adams. Aaron, are you with us? Okay, not seeing Aaron. We're going to move down the alphabet. Oh, Representative Bradstreet.
Yes, thank you, Madam Chair. I'd just like to point out I'm still having weak internet reception, and I think this points out why we should be meeting in person if we can at all. Secondly, are we talking about the original bill or the amended version of the bill? Is that the one what's actually before us today?
The amended version that Senate President Jackson presented, that's what we are discussing. And for folks who are trying to pull it up, Steve did pop it into the chat so that you can have that.
And how long has that been available to the public?
That I would have to ask Senate President Jackson. We don't normally go back, but because wires are crossed, Senator Jackson, if you could just inform us how long the amendment's been available.
I provided that to the committee just over 2 weeks ago and asked them to put it out to all persons of interest.
So thank you, Senator Jackson. And these are all up on our committee website. When you click on the bill, you should be able to go through the online system. And I absolutely hear you, Representative Bradstreet, and that's why on the being in person, but we're in the system we're in and we're making the best of it. And we have a amazing hybrid system being tested. So like all members of the legislature, we're all working as hard as we can in a citizen's perspective. And we're all completely amenable and understandable that internet isn't so great on a windy day in Maine. And, there's always a bunch of obstacles in front of us. So with that, we're going to switch on to folks in opposition. I'm going to keep going down the alphabet. Do I have Silas Ames with us? Not seeing Silas. Okay, I'm just going to keep going down names. Kurt Babineau. Kurt, if you're here. Okay, not seeing a Kurt. And what about Donald Cole? Do we have Donald Cole with us? Not seeing Donald. Troy Condon. Oh, Senator Hickman.
Thank you, Madam Chair. You, of course, are doing a great job. Sometimes when people aren't here, when they've signed up to testify, I would humbly suggest you just ask folks who are attending to raise their hands, and then you can just move them in that way.
Yeah, I think at this point, considering that we just went through about 5 folks who are not present, if you could please raise your hand if you were here to testify in opposition to this bill so I can port you over. And I will take you alphabetically. And look, all of a sudden, a flurry of hands. Thank you, Senator Hickman. I'm going to port over Dana Doran. You're up first in the alphabet. We'll go from there. And hopefully the wormhole works. Okay, Dana's coming over now. After Dana, Tom Cushman, I'm going to promote you right now and you will be after Dana. And with that, Dana, the floor is yours.
Hey, good morning, Senator Daughtry and members of the Joint Standing Committee on Labor and Housing. My name is Dana Duran. I'm the Executive Director of the Professional Logging Contractors of Maine. PLC is a trade association that was created in 1995 to give independent logging contractors a voice in the industry. Our membership includes about 210 contractor members and an additional 100 associate members. Our membership employs over half of the quote workers that have been mentioned previously in testimony in this industry, and our members are also responsible for 80% of Maine's annual timber harvest. I've provided my written testimony, so I'm going to try to summarize this. I know I'm on the clock for 3 minutes. Appreciate the opportunity to testify on behalf of our membership across the state of Maine and all 16 counties in opposition to LD 1724. We respect the sponsor's intent and the fact that he represents more than 50 of our small business members in his district. But this is nothing that our industry, our membership has asked for. And to be quite honest, we were not consulted on this bill even over a year ago when it was first entered as a bill title in the first session of the legislature. Most folks in the room are aware of what's happened to our industry, especially with COVID-19. Our industry lost about 30% of its harvesting capacity, including 2 million tons of production at the J Mill in April of 2020. And it's been a direct loss of $186 million of economic activity. Making a bad situation worse, I want to highlight inflation. We did a survey of our membership 2 weeks ago, and our members came back and said they're experiencing an average of 24% inflation for parts, equipment, services, and fuel since January 2020, and diesel fuel has gone up 75 cents in the last 5 days. I bring that to your attention because this bill will do nothing to create new markets. It will not help with inflation, and it is not something we've asked for. I'm again going to summarize, but I'm going to bring forth a couple of the major issues that we see. This is going to create an open-ended bureaucratic logging dispute resolution board within the executive branch. It's not clear if the board's going to hear disputes of landowners, mills, contractors, subcontractors, or the employees of contractors. And I'll highlight that the folks you heard from the union mentioned workers, the sponsor mentioned contractors, and I'm not sure who's actually telling the truth as to what this is going to represent. As written, the board could hear disputes from anyone in the industry, including the employees of our membership, and that's not where we want the employees of our members to bring their issues. We already know that in state government, there's a Maine Labor Relations Board, a Workers' Comp Board, an Unemployment Commission, and a Maine Human Rights Commission, and that's where workers are free to take their issues. Currently, there is no other organization in state government that hears the disputes of contractors or businesses other than in the judicial branch.
Sir?
Lastly, yep.
You're at your time, so if you wouldn't mind summarizing your thoughts.
I will. Lastly, as Senator Jackson mentioned, there is a Maine Agricultural and Bargaining Board, which allows cooperatives to be created. That is the only place in state government that allows businesses to join and bargain collectively. And since that already exists, this would be duplicative. So with that, I'll reference you to the rest of the issues that I brought up in my testimony, and I'm happy to answer any questions.
Thank you so much. I have a question from Senator Guerin, followed by Representative Cuddy. Senator Guerin.
I apologize for not putting on my camera, but it's just foggy today. So you represent a lot of the people, Mr. Duran, that I represent. And I haven't heard from any of them asking for this bill or in support of this bill. In your membership, how is that playing out? Are you seeing that same thing, lack of support for this bill?
Yeah, in fact, unanimous lack of support for the bill. We've had this bill out before our membership weekly since the beginning of the legislative session, asking them for their opinion, good, bad, or indifferent. All I've received is negative feedback. None of them want to see it move forward.
Thank you.
Representative Cuddy?
Thank you, Madam Chair. And thank you, Mr. Duran, for your testimony on this bill. Have your members seen any of the issues that the sponsor brought up with regards to having difficulty with landowners?
So good question, Representative Cuddy. I want to preference that before getting into the meat of the question to make sure folks, especially on the committee, understand that not everyone in the logging business works for a large landowner. You've got to understand that across the state there, in the logging business alone, there's probably around 300 contractors. I would say 80% of those contractors work for small landowners. So there's, I want to make sure there's context to your question because not everybody works for a large landowner. So it's been brought forth that the issues that are potentially going to be solved, as you just posed, are for contractors because they all work for large landowners, and that's not true. And so have contractors, to direct response to your question, have contractors had issues in their own contracts, whether it's with a small landowner, with a consulting forester, with a mill, with a large landowner? Yeah, sure. They choose to be independent contractors for a reason, because they want to be in business for themselves. They want to make a profit. They want to employ folks in their local area. And because of that independence, they choose to solve their own issues. And I think that's reflected, as you'll hear today from our membership, that they've had issues, but they want to solve those independently.
Quick follow-up, Madam Chair. So the members who do have these issues, if you're dealing with somebody with whom they don't have the resources for a legal team, maybe it's easier to hash out. But do you find that you have members who do end up dealing with a large landowner where the legal costs alone could be prohibitive for them to push back against maybe not a change in an agreement, but something different than what they expected?
I haven't had one of our members come to me specifically. They deal with their own business relationships, and as a trade association, I can't get involved in those business relationships that they have because of antitrust law. So whether or not they have chosen to move forward with arbitration or with a civil suit, I couldn't tell you, because they're not going to share that level of information with me, and I'm not privy to have that information.
Thank you. Senator Hickman?
Thank you, Madam Chair. Thank you, Mr. Duran, for your testimony. Did you refer at the end of your testimony to the Maine Agricultural Bargaining Board of 1973? Is that what you referred to?
I did.
Okay. I don't know if you are aware, but I think that is defunct, but we can certainly get that information from Stephen Langland. And are you aware that it does not cover anything other than producers of commodity crops? It would not cover anyone in this industry. Are you aware of that? If it does still exist?
I'm being completely respectful when I respond to this, Senator Hickman. So in the first session of the 129th, I think Senator Jackson referenced that law was changed, and the Governor Mills, allowed that to become law, and it actually allows producers and haulers in the forest products industry, specifically loggers and truckers, to create cooperatives. So that's actually in public law. It was passed in 2019 and became law.
We'll look that up for work session, Mr. Langland. Thank you. I don't see it, but okay. We'll figure that out.
Sure.
Definitely. Representative Rader?
Thank you so much, Madam Chair. I have a small technical question and then sort of a larger philosophical question. I don't know. The first technical question is there an industry-wide standard that delineates large landowners versus small landowners?
I don't think there's an industry, well, I should say, in response to your question, there's not a statutory definition of large versus small. I mean, generally, most of us in the industry denote a large landowner as owning somewhere in excess of 10,000 acres. But that, of course, some may look at it as 500 acres or 1,000 acres or more. So there's no industry-wide nor statutory definition.
All right. And Madam Chair, may I ask my follow-up? It has very little to do with the first part of the question, so I apologize for that. If a logger is only contracting with one person, wouldn't they then be an employee of that person? Like, I'm trying to wrap my head around the differences between the contractors and the employees, because the industry that I worked in before coming into the legislature relied heavily on contractors, and all of that has been pushed aside because we were required to show up at a certain time and do a certain, we were functionally employees. So I'm trying to understand the argument here between contractors and employees. Thank you.
Sure. Very, very good question, Representative Rader. It's a question that we've posed, I think, similarly to Senator Jackson, to both the U.S. Department of Labor, but also to the Internal Revenue Service. The IRS is actually the authority that defines whether or not you're an employee or a contractor, and they have a 4-point test that determines, are you, as a quote contractor, doing the same work every day? Are you being directed as to how you do your job? Are you forced to go to training? I think there's one other part to that test, and that will determine whether or not you are an employer or an employee. And so, again, these are federally regulated questions, and we pose the exact same questions because we've had the same similar concerns, especially with respect to training. There are some issues out there that have existed for over 20 years about whether, contractors and their employees must go to training as a mandate in order to sell wood. So, we have similar questions, and we've posed those to the federal government, similarly to Senator Jackson.
Okay, just quickly on the 4-point test, it's my understanding, and just let me know if it's yours as well, that a position only has to meet one of those 4 guidelines in order to be considered not a contractor and, in fact, an employee. Is that your understanding as well?
That is my understanding as well, yes.
Thank you.
Yep.
Do you have any further questions from the committee? Seeing none, thank you so much for your time this morning. We are now going to move on to Tom Cushman. I'm just going to start pulling people in the order that they are in the participants panel. So Mike Rowland, I am porting you over, and you will be going after Mr. Cushman. And Mr. Cushman, the floor is yours.
Good morning, committee members. My name is Tom Cushman. I own Maine Custom Woodlands. We're located in Durham, Maine, and we employ 27 people here and work within a 60-mile radius. We work 100% on small landowners, being less than 1,000 acres. That's how I would categorize it, I guess. We do business with 18 to 20 different customers, mills, firewood operations, sawmills, just wood yards all around the state. And just testifying in opposition to this bill today, I just can't see how it would do anything to help my business at all. It leaves things open-ended, I feel. It doesn't, can employees use it against my company? It doesn't make any sense to me.
Do I have any questions for Mr. Cushman? Seeing none, thank you for taking the time to be with us this morning. And it seems everyone is really sticking to the 3-minute brevity. So thank you to everyone. With that, I have Mr. Rowland and Tony Madden. You're going to be on deck, so I'm promoting you over right now. Mr. Rowland.
Thank you. Good morning, Senator Daughtry and members of the Joint Standing Committee on Labor and Housing. My name is Mike Rowland, and I'm the Director of the Bureau of Labor Standards at the Maine Department of Labor. On behalf of the department, I am offering this testimony in opposition to LD 1724. And so I'd start out by saying there are a few distinct components of this bill, and I'm going to talk about each one of them separately. First, We see no problem with the reduction from 30 to 14 days of the time within which proof of ownership of equipment ownership must be submitted by an employer applying for temporary foreign workers in a logging occupation. So first, that's our position on that component of the bill. A second component of the bill involves federal cabotage laws, which is outside of our jurisdiction and not a subject that we're particularly competent to comment on. So we'll let that go. Now, lastly, there is the part of the bill that's received most of the discussion today. It would establish within the Department of Labor a logging dispute resolution board to hear disputes of various issues in the logging industry. As we have no special expertise regarding the nature of an extent of disputes requiring resolution in the logging industry, other than those involving complaints and violations of employment law in general, it's difficult for us to assess the need for this board. But we do have several questions or concerns about the provisions of the bill. Overall, while it ostensibly grants powers, quote, necessary to carry out its functions, unquote, it's unclear what those functions are. More specifically, there's no mandate for parties to appear before the board. We see no clear authority to render recommendations or decisions. There is no provision for appeals of those decisions administratively, and similarly, there's no provision for judicial review of those decisions. And there's no apparent enforcement mechanism, the way we read the bill. So for those reasons, we're opposed to LD 1724 and urge you ought not to pass. Other questions and concerns regarding the operation of the board would more immediately affect the State Board of Arbitration and Appeals. And we understand that the Maine Labor Relations Board Executive Director Daly will express them in separate testimony. And I will be happy to be here for the work session if that's what you like, or answer any questions you have right now.
Thank you so much. I have a question from Senator Hickman.
Thank you, Madam Chair. Thank you, Mr. Rowland, for being here. Do you have any familiarity with the Agricultural Bargaining Act of 1973 and whether or not it applies to loggers?
None whatsoever.
And do you know how any dispute would currently be adjudicated?
I can really only speak to disputes regarding an employee relationship, because that's the area that we work in. A dispute among independent contractors is another situation altogether that we have no immediate authority or expertise particularly. And I think the very good question has been raised by you, I think Senator Hickman and others on the committee, that what is the definition of an employee versus an independent contractor, and how is that determined? And that is a very basic question for us. It's a very important question, but it's not a question that I can give a blanket answer to. I wish I could, but it's really on a case-by-case basis.
One final question, Madam Chair. Thank you. And do you have any evidence, or if you could bring it to the work session, that would be great, of any employer of any logging industry that in the logging industry that has any kind of complaint that your office has dealt with, or the board has dealt with?
Yeah, another good question. I'm not aware of any, but I will check. And specifically, I'll check if there have been allegations of misclassification of employees versus contractors, if that's, yeah.
That would be appropriate.
Yep.
Thank you, sir. Appreciate it.
Up next, I have questions from Representative Cuddy, followed by Senator Guerin.
Thank you, Madam Chair, and thank you, Director Rowland, for your testimony. I didn't follow the last piece of your testimony. You mentioned Mr. Daly, Director Daly will likely be discussing it. So if you want to let him cover it in more detail, but I just wasn't sure what you were talking about, I guess.
Yeah, okay. Well, so the Board of Arbitration and Appeal and Conciliation that's named in the bill is within his purview, right? That's part of the main Labor Relations Board structure. And so that he has some concerns, I think, or maybe more questions about how the proposed board would operate within his agency. And so I'm going to let him address that separately. That's not something I have intimate knowledge of.
Thank you.
Senator Garin.
Thank you, Madam Chair, and thank you for being here, Mr. Rowland. I wanted to go back to Senator Hickman's question about was there any recourse if there was a problem? And I believe the recourse would be the courts if it was not a labor violation, as other small businesses would have the courts as their settlement ground. Would you agree with that?
Yeah, to the best of my knowledge. And I think that's what Senate President Jackson was also saying, is that in the absence of this board, the courts would make those determinations around contracts in the lack of an employment relationship.
Thank you.
I have Representative Brader, followed by Representative Cuddy.
Thank you so much. And thank you to Senator Garin for giving me the idea for this question. Mr. Rowland, do you have any idea about the average cost of a lawsuit such as that?
No.
Okay, thank you.
And Representative Cuddy?
Thank you. I'm reminded that in his testimony, the sponsor mentioned that there was an earlier board similar to this in 2003 or 4. And I'm wondering, if you don't know now, if you could find out for the work session, what the department's position was at the time on that board.
I'll do my best. Yeah.
Do we have any further questions from the committee at this time? Seeing none, thank you so much, Mr. Rowland, for being here this morning. I'm going to kick it over to Tony Madden, and after Tony, I'll be porting over Jim Mitchell. So Tony, the floor is yours.
Can you hear me okay?
Unclear.
Good. Okay. Well, good morning and thank you, Senator Daughtry and members of the Joint Standing Committee on Labor and Housing. My name is Tony Madden. I'm a third-generation logger. My company, A.W. Madden Incorporated, is located in Milford, Maine. With a team of 16 employees, we harvest and transport timber for both large and small landowners, including the state of Maine public lands. Thank you for providing me the opportunity to testify in opposition to LD 1724. I've been in the logging business for 42 years and always had the ability to negotiate with my employees, truckers, mills, and landowners, including the state of Maine. I think this bill will sow mistrust between all parties in the industry, and I don't believe we need Augusta negotiating for loggers. Thank you.
Thank you so much. Do you have any questions from the committee at this time? Representative.
Thank you, Madam Chair, and thanks for being here, Mr. Madden. When you characterize yourself as a company owner, right? So you have a company that does logging and employs people to do that logging. Is that correct?
Logging and trucking and also some road construction too.
Okay, and then my question is, so vis-a-vis your relationship with the landowner, you're classified as a company that contracts with them, right? Not an independent contractor. Would that be correct?
Well, aren't they both the same? I'm an independent contractor, but I bid on jobs for the state of Maine, along with other landowners. So I'm a contractor.
But not as an individual, your company.
No, oh, no. I have employees. I have workers' comp and right. No.
Okay, thank you. And I just want to flag for our analyst, I'm trying to understand the different relationships we're looking at here in the industry between company owners, landowners, and loggers as to whether they are independent contractors themselves or employees of another company. So if we could just get a lay of the land on that, that would be super helpful. Thanks, Steve.
I have a question from Representative Pebworth.
Thank you, Madam Chair. Thank you, Mr. Madden, for being here. I understand you're from Milford.
Yes.
And are you zooming into us today from Milford?
I am. Can you see me?
It's beautiful background behind you.
Yeah, okay.
I, for one, am really appreciating not always driving to Augusta. And I'm just wondering, I appreciate people being able to give testimony without leaving so much time from their work.
Right. And I appreciate you folks allowing us to Zoom, because if I had to drive to Augusta today, I probably would not be testifying.
Yeah, and it's so helpful for us to have the back and forth. But my question for you is, if you've engaged in a contract with a landowner and then they don't pay, they somehow break that contract, what are your recourses? What would be your next steps? Should
I would take them to court. I mean, you can actually, it's pretty simple. If it's depending on the dollar amount, you can go small claims, but I've never had any landowner break a contract with me. I don't know how they would. They know that there's legal recourse, so there's no reason to break a contract. And I'm not even sure that's the issue behind this bill anyway. I just think that Senator Jackson's bill had more to do with loggers that want to negotiate for more money. But I guess I'm not sure.
Thanks for your answer.
Do I have any further questions from the committee at this time? Seeing none, thank you very much. I'm glad you're able to be here and also highlighting one of the few positives we have for our current setup. So thanks for being available. And with that, Jim Mitchell, the floor is yours. And Molly London, I'm putting you on deck and porting you over.
Thank you, Madam Chair. Senator Daughtry, members of the committee, Jim Mitchell on behalf of Irving Woodlands, testifying in respectful opposition to LD 1724. Quick background on Irving. Here in Maine, Irving owns and operates 2 big sawmills. They also own and manage more than 1 million acres of forest land, employ roughly 430 people with average annual pay of about $41,000 plus benefits. But the truth is, without able, successful logging contractors, Irving cannot succeed. They work with more than 100 Maine-based contractors who employ a little under 200 Mainers, and these people are critical to Irving's work in Maine. On the environmental front, Irving has a long record of excellence. Their products qualify for FSC and SFI certification that requires meeting strict environmental management standards and socioeconomic metrics, demonstrating a commitment to their communities. Part of that analysis is feedback from stakeholders, including contractors, how they are treated, and the quality of the business relationship. Of note, Irving has planted more than 1 billion trees in Northeastern North America, and more than 78 million of those are right here in Maine since 1985. The company's main operations began in 1946. Turning now to the bill, I respectfully call your attention to lines 10 to 12 on page 2 of the printed bill. This language is similar to language adopted from LD 188 that was passed last session. And currently that legislation, that law, is subject of active litigation in federal court. The language appears to prohibit holders of H-2A visas from hauling wood within Maine. Our view is state interference in immigration matters is prohibited by law and the Constitution. Furthermore, the 14th Amendment explicitly states, and I quote, "Nor shall any state deprive any person within its jurisdiction equal protection of the laws." Yet this provision appears to discriminate against holders of H-2A visas who are undoubtedly persons. The major purpose of the bill, of course, and the subject of much discussion, is establishment of a logging dispute resolution board. Obviously, the legislature and the agencies and boards it creates have a legitimate role in regulating contracts. And let's face it, contracts periodically lead to disputes. Irving seeks to avoid formal disputes by meeting with their contractors every 8 weeks, trying to make sure both parties are living up to their obligations. If there are disagreements, they are, hopefully, hashed out. But both parties can seek binding arbitration in Bangor before a neutral arbitrator jointly selected by the parties. We believe this mechanism is the appropriate place for these matters to be settled, because depending on the services being provided, there may be confidential business information that is central to the dispute. The bill is not clear on how such information would be protected before a public board. In addition, the bill is not clear on the scope of the board's authority, or how one appeals its decisions, or the applicability of the APA, or the role of the judiciary in matters related to logging. For these and related reasons, we respectfully urge the committee to consider an ought not to pass vote. Thanks for considering my testimony, and Madam Chair, I'd be pleased to try to answer any questions the committee may have. Thank you very much.
That one queued right away. We got Representative Cuddy.
Thank you, Madam Chair. Thank you, Mr. Mitchell, for your testimony on behalf of Irving today. You mentioned the binding arbitration that is available. Are you aware of anybody using the binding arbitration?
I'm not, but I'll find out if it has been used in the past, Representative.
I would appreciate, thank you. That goes to a lot of what the sponsor was saying. Yeah, actually, thank you. That's good.
Do I have any further questions from the committee? Seeing none, thank you for your time, Mr. Mitchell. Molly London, the floor is yours. And Peter, I'm not going to massacre your last name. So Peter, I'm promoting you and you are on deck. And with that, Molly, the floor is yours.
Thank you. Thank you all for having me today. Just quickly want to just put my voice out there. I am a Maine licensed forester and I run a logging company with my husband. He is the 4th generation in the state to work, or for this company to work in the woods. But we are the 1st generation as loggers. His father and grandfather were did forest road construction and plowing, and then we started hauling logs, log trucking, and now logging. And so we work out of Milo. Our company's located in Milo, so we're really central in the state. We work in a lot of different areas. We altogether have 16 employees. We have 3 separate logging crews on 3 different large landowners. But the beauty of our business is that we do have the opportunity to work for any landowner if we want to. Small landowners as well. We could walk away from, or we could move a crew away from one of the larger landowners and work on a small landowner if that was our decision. We could do that. I wanted to testify today against LD 1724 because of that reason. We have the freedom to make these choices for ourselves, and I do agree with some of the things that that were brought up. We do have some issues with rates and pay in our industry, absolutely, but I don't believe that this is the place in public to deal with them. We have the opportunity to go to court if we need to. There are lots of places that a landowner or an employee could bring a dispute if they had one. And we have the opportunity through our contracts to bring forward any disputes that we have with our landowners or whoever we're contracted with. So having that in a public board is not in our interest. Thank you.
Thank you so much. Do I have any questions from the committee at this time? Seeing none, thank you so much for taking the time to be with us, Ms. London.
Okay, I do have a question.
Go ahead, Ken.
I'm sorry.
You're good.
Thank you, Madam Chair. Thank you, Ms. London, for being here. Could you just explicate a little bit on what you said at the very end? It's not in your interest to have this kind of dispute resolution board in public. I just want to understand how that's not good for you.
Sure. From my personal viewpoint, we have rates and contracts that are private between us and the landowners or the different companies that we're working for. We are an independent contractor. We are able to negotiate those rates and negotiate the contract details with those people. And I guess I don't see the need, having gone through all the meetings that we have with the people we work for to try to come up with those contract terms. I don't see the need to involve anyone else or to have that open to the public. It's a private discussion that we have with the people that we work for on what we get paid and how that happens. And I don't see the need for the board to be involved with that.
Thank you.
If I could also, I wanted to mention that we also have, as part of our contracts, we're required through the workers' comp board to prove independent contractor status as well. Just going back to some of the discussion that I've heard today, and that we have to prove that we are independent contractors, that we are not answering as employees to these landowners. And that's just from a workers' comp standpoint, that they can't, if someone were to get hurt on their land, that they wouldn't be liable. But we do have to go through that process to separate us from being employees of that person.
Thank you. I have further questions from Representative Rader and then Representative Gear.
Thank you, Madam Chair. Thank you, Ms. London, for being here. You mentioned that if there was a dispute that you couldn't resolve through negotiations, that you would go to court. Have you had to go to court before? And if not, what resources does your company have to provide for the lost time, perhaps, of going to court and the expense?
We have not had to go to court before. We have had a situation with a landowner where there were some problems in our contract and there was talk of going to court, but we were able to settle that through negotiations with the landowner and others involved. So we have not had that happen with us. And if we did have that come up, we would contact our lawyer and we would try to do that as best we could.
Thank you so much. Do you have a follow-up, Representative Rader? All right, Representative Gear.
Thank you, Madam Chair, and thanks for being here, Ms. London. When you said we have to go before the Workers' Comp Board to prove that we are independent contractors, can you help me understand who is the we in that? Is that each individual employee? Is that your company as a whole? Who is being defined as the independent contractor in that? And is in fact the case? Is my understanding correct?
Yes, so that we have to do that as a company. Our company fills out a form from the Workers' Comp Board to prove that our company is an independent contractor.
And then your employees are your employees.
Yes, our employees,
their work.
Us, and not to the landowner. It's proving that our employees that are working on that landowner's ground, they're doing what we're asking them to do, not what, and it has nothing to do with the landowner.
Thank you.
Do I have any further questions from the committee? Senator Hickman.
Thank you, Madam Chair. Sorry for asking another question. Ms. London, I guess I'm trying to understand if they are your employees on the job site of someone that your business contracts with, and you just said you have to sign a form to make sure that they're doing what we ask them to do versus what the landowner that you have contracted with asks them to do. Doesn't that ever get jurisdictionally muddy for the employee of your business that is being considered a contractor by the person that your business has contracted with?
I see what you're getting at, that it seems like it could. We have not had that experience. We have foremen in place that basically the person we're working for, the landowner or the management company that we're working for, we are contracted for a service. They ask us to do this cut, skid, load, and haul service. And if there's an issue immediately right on the ground with the employee, they are asked to contact us, either the owner or the foreman, to address that with the employee. It's not because we are an independent contractor. So it is not something that if there ever were to be an issue that the landowner did not feel that specific employee were completing the task they wanted, that landowner could come to us as the person they have the contract with, and we would settle that with our employee.
Thank you.
Senator Guerin.
Thank you, Madam Chair, and welcome, Molly. I'm glad to have another small business person here today. My question is related to Senator Hickman's, and I think it appears that he is viewing your business as something other than a small business, and maybe I've got that wrong, but maybe you can clarify for us. Your employees aren't contracting with the landowners. You're contracting with them, and just like if I sent out my crew, they would be working for me. They wouldn't be working for the restaurant that my crew was going to. Would that be a fair example?
Yes.
Thank you.
Do you have any further questions from the committee at this time? Seeing none, thank you so much, Ms. London, for being here and for your testimony. Up next, we have Peter. You'll have to tell me how to say your last name, but first, I just want to let Patrick Strouch know I'm putting you in on deck. And Peter, please let us know how to say your name.
Good morning. My name is Peter Triantafilo, but generally speaking, it's Peter T to most folks. So
I can manage.
it is a rather daunting name. Thank you for having me here today, distinguished members of the committee. My name is Peter Triantafilo. I live in Orono, and I'm representing Huber Resources Corp. I actually retired from them a couple of years ago, but as part of my failed retirement, I still represent them in things like this and do a lot of forest modeling and stuff still. Huber Resources manages about 600,000 acres of timberland in the state of Maine for a variety of clients. And I just want to preface by saying that, because we've heard a lot about this, that good, competent logging contractors are a very precious commodity. And some of the toughest competition that I've dealt with over my career is not so much selling wood or where I'm going to sell it or what price I'm getting, but securing those logging contractors and not having them stolen by another landowner by paying more. And that might vary by regions in Maine, but where I've done my work, logging contractors are not easy to come by and they're very precious. This bill really confused me in a lot of ways. I couldn't figure out what it was getting to and why it was duplicating things that already existed. It's already been said previously that the court system is available for contractors or their businesses to settle disputes. I can't tell in this bill where if something comes before this dispute board, whether you can still go to the courts or not. Is it subservient to the courts or does it supersede them? I frankly just don't know. So I can't opine on it, but it makes me nervous because I can't figure out how this board would work. It's similarly, some folks have said that it applies only to logging contractors and not employees. Other people have said it might. When I look at it, it's pretty wide open. It applies to any kind of dispute within the forest products industry. And that has, that brings up issues. All of the work that we do with the independent contractors that we work with are done on a contractual basis. All of the prices are listed in there. To get at a point that was mentioned previously, we cannot go and talk to the employees of the contractor. The contracts actually list who the authorized people are that we can talk to if we have an issue. Just going down the board quickly, I don't want to eat up my 3 minutes before I'm done. The board has a pretty open-ended mandate about what they can look at. It could almost go beyond forestry. They have all the powers they need. That's not defined. It says that the costs of the arbitration are borne by the party that loses, basically, but it doesn't say who's going to do the arbitration or how it's going to be charged and whether they're billing for their time or what. I can't figure that out. That concerns me because, again, if you go through this process and pay for arbitration, could you then go to the other arbitration board of the state or go to the courts with systems that already exist? I can't figure it out. I just think it duplicates what's already there in place, and that seems to work. In the 25 years that I worked for Huber and the time since that I've been a contractor, we've only ended up going to court once on an issue, which we then settled. They're rare. And
Sir?
Yes.
I'm sorry, you're at your 3 minutes. If you could sum up, that would be great. Thank you.
I will sum up, yes. I don't think that, just briefly, I don't think that changing from 30 days to 14 days, it makes sense. 30 days is more reasonable, especially considering how long it can take to get the data together and report it properly. But I'm not sure that that's a drop dead issue either. With that, I would urge you ought not to pass, and I'd be happily answer any questions.
Thank you so much. Do I have any questions from the committee at this time? Seeing none, thank you for being here. Up next, we have Patrick, and I am porting Brent Day over right now. Patrick, the floor is yours.
Thank you. Senator Daughtry and members of the Labor and Housing Committee. My name is Patrick Strauch. I'm the Executive Director of the Maine Forest Products Council. We're a large trade association looking out after all the supply issues from loggers to landowners to mills. We have sawmills and pulp mills as members. So it's a broad spectrum group that tries to look after the overall interest of the industry. I'll dive right into the bill sections that I wanted to talk briefly about. There's the time reductions that are in sections 2 and 3 relate to the proof of ownership rules. I think Senator Jackson and I have a long history with those rules. The 30-day notification period was established to ensure such significant fees and fines were set within a reasonable timeline. The fines are around $5,000 to $25,000 for paperwork timing errors. So that's why that bill has a history of moving around in terms of what's fair. Section 3 is a provision requiring Maine employer employs a bond worker, presumably referencing H-2A workers, to certify the employer is not required to engage in point-to-point harvest. This was a bill that we dealt with in the last session, LD 188, which the legislature passed, but which the council has challenged in federal court. And that challenge was affirmed by the federal courts, and a preliminary injunction was recently granted to the plaintiffs. So I guess the best thing I would recommend there is that the committee seek verification of this court action from the Office of the Attorney General before you move forward there. Section 4 deals with the Logging Dispute Resolution Board. It has a number of challenges to it. It doesn't define what it means to hear a dispute. Is the board intended to be a forum for litigation or a regulatory body or both? The legislation doesn't really say. It's an open-end authorization to hear any dispute related to the logging industry that encroaches on a number of state and federal agencies. For instance, the Maine Human Rights Commission has a function in this. Maine Department of Labor, Maine's wage and hour law, federally OSHA, and United States Department of Homeland Security, U.S. Immigration. Lots of things are contemplated in this bill that may be usurped. So you can read the rest of some of the concerns we have from a legal point of view of this bill. In conclusion, we believe the industry is rebounding from some serious setbacks, and it's clear we need to make sure the logging and trucking sector can recover. Currently, there are not enough workers to go around, particularly in some of the regions we're talking about. So we need to focus more on developing markets, getting people to work, moving materials, and we think that's a more productive kind of thing to be thinking about. So for these reasons, we ask the committee not to support LD 1724. Thank you very much.
Do you have any questions from the committee? Yes, Senator Hickman.
Thank you, Madam Chair. Thank you, Mr. Strout, for your testimony today. Good to see you before.
Good to see you too.
In section, let's see, I need glasses. In section 3 of the bill, on page 2, other than changing the date, the 30 to 14, do you have any objection to the recommended new language that says the employer shall certify to the Maine Department of Labor that the employer is not requiring the bond worker to engage in point-to-point hauling of forest products within the state or to otherwise violate federal cabotage laws? Do you have any objection?
Yes, that was the reference I made to the court action that the council has taken. And that provision is exactly what's in LD 188. So the two are very similar. The judge recently ruled that LD 188 is unconstitutional. So I'm just bringing that to the committee's attention, that you have a bill that may have the same liabilities that were in LD 188. So that's why the best way to deal with it is to ask the Attorney General what to do with that section. I know what I'd recommend you do, but you need to have the Attorney General give you.
So, Mr. Langland, can you make sure for the work session that we can get the ruling that Mr. Strout has referred to, and the court's decision would be great. Thank you.
Thank you.
Do you have any further questions from the committee at this time? Seeing none, thank you so much for being here. Brent Day up next, and Michaela Voisin, I am porting you over.
Hello all. Thank you for
you can hear me, but we can't see you.
Oh, I don't know if you want to see my pretty face. Let me see if I can figure out how to put that on. Can you see me now?
All good. Floor's yours.
I'm handsome. I'm a handsome man. Hey, I just wanted to thank you all for letting me join in on this and speak on this. Don't do this a lot, so excuse my grammar or anything else that I may do wrong. My name is Brent Day. I'm the owner of William Day Jr. and Sons in Southern Maine. We carry usually about 50 employees. Here in the southern part of the state, we bounce back and forth across the state line as well quite often, as in Maine and New Hampshire. And I'm speaking in opposition to the bill. It's kind of listening. I've been listening in for the last hour or so on the different topics, different speeches, and I guess I'm kind of confused on what we're actually, this bill is trying to accomplish as far as the fair rates or the employee or the contractor. I think the bill is maybe geared toward a very small pool of folks down here in the southern part of the state. I mean, we have very competitive and aggressive wages. Compensation is very, very fair. I mean, we're dealing with the Shaw Brothers, the Grondins, the bigger, larger companies in the state. So we have to compete. We have to compete to keep our employees healthy, to keep them fair wages, fair benefits. As far as contracts, most of our contracts, like I said, are for smaller landowners. We did do a small piece for Seven Islands this fall. Very, very cordial negotiating. A very professional way. I think most of you are going to find that most of us loggers are very, very resilient. We're very proud people. And I think this bill of basically sticking government in my business, I'm all set. I don't think that's something I'm willing to accept or go down without just hearing my voice. That's all. So thank you all again for hearing me on this. I do appreciate it. And anything else I can do, I'm here.
Thank you so much, and thank you for taking the time to testify this morning. Do I have any questions from the committee at this time? Seeing none, thank you for sticking it out. We have Michaela up next, and then I'm going to add him over.
Right. So before the Committee on Labor and Housing in opposition to LD 1724, an act to create a logging dispute resolution board and require proof of ownership document to be available within 14 days of request. Hello, my name is Michaela Vizin. I am a senior at University of Maine at Farmington, but first and foremost, I'm the daughter of Ben Vizin, owner of Vizin Brothers, Inc., first generation logging company from Fort Kent since 1999. My father, uncle, and grandfather have owned and managed this company logging business, and they have been able to make decisions for their business and have done an excellent job of managing the challenges they face year after year. I have seen firsthand their struggles and successes. I am here to speak on behalf of my family's business in opposition to LD 1724 and how it will affect my family's logging business. Recently, the logging industry has been in challenging times due to the pandemic, loss of market, labor shortages, and rising inflation. Loggers need help, and LD 1724 is not the answer. The problem with this bill is that it is very open-ended and has no limit to its authority or power. There is a fear of what this bill could do to logging businesses such as ours. First, this bill is not clear to who will be able to bring a dispute to resolution board. It could be VBI's employees, land companies we provide service to, or the mill we supply wood to. How can this be beneficial when we are struggling to find qualified people to work independently and hopefully operate efficiently, enough not to cause a financially crippling breakdown? We already have a system through the Department of Agricultural Conservation and Forestry to hear industry disputes through a co-op system called the Maine Agricultural and Bargaining Board Act of 1973. Also, our employees can already voice their concerns to the Department of Labor's Unemployment Insurance Commission and Maine Labor Relations Board, or even the Maine Human Rights Commission. Second, the resolution board does not even have one individual that would represent the logging community. My family's logging business does not need a resolution board that does not represent the logging industry to tell them how to run their business. Lastly, our business also does not want employee and subcontractor relationship, landowner and mill contracts, and any of our other businesses' relationships to be an open book and potentially analyzed and shared. These negotiations are often driven by need and availability and not a standard. This may seem minor, but we do not want any of our private business relationships or documents brought to a public dispute board. In conclusion, what our industry needs is access and better and stronger markets for our products we produce, help with increasing supply costs and access to trained employees. Thank you for your time.
Thank you so much. Do I have any questions from the committee? Seeing none, thank you for your time and patience this morning and for being with us. Scott Madden, you're the last one I have in the queue for opposition. I've tried to give you an invite to become a panelist. I'm going to try it one more time. See if it works this time. Okay, coming through. Now, if there's anyone else left in the attendee portion who had hoped to testify in opposition to this bill, please raise your hand. Otherwise, we are going to move to our one, neither for nor against. With that, Scott, you have the floor. Scott, are you with us? Can you hear us? Scott, if you're able to participate, if you can turn on your video or unmute so we know you're ready to go.
Can you hear me now?
We can hear you now.
Okay, I'm in a harvester just outside of Milo, Maine, cutting wood this morning. Thank you for taking the time to listen to me. Definitely keep it out of my face. Sounds like the only thing we're trying to get to is whether or not you're a subcontractor or not. My wife and I own Madden Timberlands. I've been 45 years doing this. Bought my first piece of equipment at 17. I've been everything from a subcontractor to a business owner. I don't need Lord, and respectfully, Troy, I think Troy's heart is there. Troy has helped us with a few things. Troy, please don't take this with disrespect, but I don't need the AFL-CIO or anybody else helping me control it. I've worked with almost every large landowner in the state. With people that only own 1 acre of land. I have people that have worked for me for over 20 years that we consider family. So it's like it's creating a problem that we don't have. This industry has problems that we can solve. Our time would be much better served solving it, something that would further our industry.
Thank you so much, Scott. Sorry, my internet cut out there for a split second, but I think I'm back with everyone. Any questions from the committee at this time? Seeing none, thank you for taking the time to be with us, especially during your workday.
Thank you.
And up next, we have Chris Fife.
Good morning. Thank you. Apologize, I had a little trouble with the Zoom connection.
No worries.
But good morning, Senator Daughtry and members of the Labor and Housing Committee. My name is Chris Fife, and I'm a Public Affairs Manager for Weyerhaeuser. Weyerhaeuser owns and manages 840,000 acres of timberland in Maine, primarily in Somerset and Scottsdale counties. Our timberlands are third-party certified through the Sustainable Forestry Initiative standards. And of course, we support outdoor recreation, healthy wildlife habitat, and also carbon capture and storage. We rely on Maine loggers, truckers, and road contractors to harvest our timber and get it to the mills. We're proud to be part of the forest industry supply chain in Maine, which in 2019 contributed a total contribution of over $8 billion to Maine's economy. Many of the loggers that harvest timber for Weyerhaeuser work for multiple landowners of varying size and with varying forest management objectives, as we've already heard today from others. The forest landowners, independent logging contractors in Maine need each other to maintain healthy businesses, a healthy industry, and a healthy forest. The stress on logging contractors in Maine is real. Loss of low-grade wood markets, a shortage of qualified operators, severe weather events, and now dramatic increases in the cost of fuel and parts. When a logging contractor chooses to come to work for Weyerhaeuser, two things are a priority for us. First, ensuring safety concerns are recognized and addressed. And second, having regular conversations about health of their operations and working together to overcome challenges identified. And I think you've heard this echoed by some of the other loggers, not loggers who work for us, but I think it seems to be consistent throughout the industry and through working with large landowners that nobody has a desire to escalate things or to see people go out of business. There's a lot of competition for good loggers, and we want to ensure that we're addressing the barriers to them being successful, and that together we can both win and have successful businesses in the state of Maine and overall have a successful industry. So a few things you've already heard, and so I'll just briefly mention these, but we feel that the Logging Dispute Resolution Board is unnecessary. Protections provided, I see that, okay, thank you. There's already protections in current law, and as has been mentioned, the judiciary, the decisions rendered by a state board typically wouldn't be characterized as arbitration. They would be administrative decisions reached pursuant to the Maine Administrative Procedures Act. And then there was already mentioned by Mr. Strout about Section 3 and LD 188 and the current, I'm sorry, this is what happens when I don't follow my notes. But the court ruling there and the preliminary injunction on that. So with that, I would urge you to not to support LD 1724, but to please continue to support the logging industry, and do appreciate the efforts and the thoughts that this committee has had towards how we can get more qualified labor into the entire supply chain for this industry. So thank you, and I'm happy to try to answer any questions.
Thank you. I have a question from Representative Cuddy.
Thank you very much, Madam Chair, and thank you, Mr. Fife, for your testimony. And I think this is probably more for Mr. Langland, Madam Chair, but the decision, or LD 188 banned H2A workers from doing this completely. This seems to be different in that it's focusing on the cabotage, which I have no idea what that is. Cabot is a maker of cheese to me. So I am admitting that I am completely out of my depth on this. However, it seems to deal with different issues. So I'm just hoping that Mr. Langland can look into that for us and give us a sense of, is this actually the same thing, or is it a different thing?
And if I could, I'm happy to just try to respond to a portion of that. Cabotage is the the interstate hauling of goods by a non-US citizen. And so by definition, someone in the logging industry who picks up a load of wood on a logging job in Maine and hauls it to a mill in Maine would be engaging in cabotage if they are not a US citizen. What the ruling said was that someone who is a bonded labor, an H2A, can do that because that's part of the job they were signed up to do. So that I think is the crux of the issue there in cabotage. But I do appreciate the question, and I'm certainly not the legal expert to dig into the details on that, Representative Cuddy.
Senator Hickman? You're on mute, Senator.
Thank you, Madam Chair. Thank you, Mr. Fife. So a preliminary injunction, as I understand it, is it a final ruling on the matter before it? But I'm still confused about the matter before the court. And I know we've asked Mr. Langland to tell us, but until then, enforcing cabotage, which is what this bill suggests to do, doesn't seem to be what the preliminary injunction was about. Is that correct?
Again, my understanding would be that I believe the issue here is bringing in the bond. So the idea that this would apply to bonded labor. Enforcing cabotage, I don't think that's an issue. It should be done if it's not being done, but it would be the bonded part of that. But I would point you to the judge's decision, and again, I think that would be making it more clear for you than me trying to describe it.
One follow-up, Madam Chair. So you are in support or in opposition to a state statute that ensures that federal cabotage laws are enforced in the state of Maine, no matter who is doing the hauling?
In support.
Pardon me? You would be in support of
support.
that? Okay,
Yes.
thank you. That's great to hear.
Do you have any further questions from the committee at this time? Seeing none, thank you so much for your time. And
Thank you.
I see that your hand is up. I will port you over. The reminder, this is for folks wishing to testify in opposition. So this is the last call for people looking to testify in opposition. Wayne, I sent you an invitation to rejoin. It says Wayne Tripp declined to be promoted to a panelist. Okay, Wayne, if you want to put into the chat how you're hoping to testify, so we can go from there. Is there anyone else present who would like to testify in opposition? Wayne, I see your hands up again. I'll try one more time to port you through. There we go. Wayne, can you hear us? Paging Mr. Tripp.
How's that?
Okay, now we can hear you.
All right, sorry, I'm trying to get pulled over next to the road. And
No worries. Glad you're being safe. Much appreciated.
all right, no, I want to thank you very much for allowing me to testify today on LD 1724. My name is Wayne Tripp. I noticed on the attendance list it had me down as Franklin. I'm actually from Frankfort. I'm in Representative Cuddy's district. Yeah, the name of my business is WC Tripp Forest Products. I started it from the ground up. I'm a first generation logging contractor. I currently employ about 12 people, and like everybody else, I need 20. And when I am fully staffed, I usually have 5 to 6 trucks on the road and 2 mechanical logging operations. So I oppose this bill for several reasons. The biggest one for me is I feel like it's a bit of government overreach. I feel like it's another layer of bureaucracy that is going to interfere with small business, which is the lifeblood of the state of Maine. I also see a lot of gray area and a lot of unanswered questions. I guess being the last guy to speak, I'm probably repeating some of the other things that were said. So I'm going to try to not do that. I feel like a lot of the things that Senator Jackson pointed out as struggles in the logging industry are things that we work out on our own as business owners. And that's part of being a small business owner, and the fittest survive. Some of the things that concern me when I listened to some of the support for the bill, it was mostly members of, sounded like representatives or affiliates of unions. And some of them talked about how this bill was for the employees or the workers, and some of them talked about how it was for the contractors. I feel like there's a lot of unknowns here, and I think the biggest thing for me is, again, I feel like it's the government interjecting itself into business where it doesn't need to be. We have enough hurdles as it is in this industry. And we don't need any more. And I noticed some of the other unknown is who is going to even be sitting on this board. I see nobody representing the logging industry so far sitting on a board or speaking in favor of this. So I feel like I'm struggling to understand a lot of this.
Do you have any, is that the conclusion of your testimony, Mr. Tripp?
Yes, it is.
Thank you. Just wanted to make sure. Do you have any questions from the committee? Seeing none, thank you for taking the time. I'm glad you were able to pull over on the side of the road and be safe. And thank you for joining us. I have no one left who has their hand raised for opposition. I do have one person who signed up to testify neither for nor against. So we are going to switch over to Neil Daly. And should be coming through. Neil, the floor is yours once you're through. Aha, Neil, the floor is yours. He asked on mute.
Sorry about that. Good morning, everybody. Senator Daughtry and members of the Joint Standing Committee on Labor and Housing, my name is Neil Daly, and it is my privilege to serve as the Executive Director of the Maine Labor Relations Board and its affiliate, the State Board of Arbitration and Conciliation, commonly referred to as the BAC. Today, I'm here to testify neither for nor against LD 1724, with a focus instead on the implementation of this bill in relation to the operations of the BAC. As you may be aware, the BAC is a tripartite panel charged with facilitating resolution of labor management disputes. Most frequently, the BAC provides arbitration services for union contract grievances. From 2004 until a 2009 change in law, the BAC chair also served as the chair of a forestry rate proceedings panel through which forestry-related parties could petition the panel to determine compensation rates for harvesting and hauling services. In part, LD 1724 proposes a creation of a tripartite panel within Maine's Department of Labor to, quote, hear disputes related to the logging industry, including disputes regarding pay violations, payout amounts, contract violations, hiring disputes, and other topics as determined appropriate by the board, end quote. The chair of this proposed board would be a member of the BAC. As drafted, LD 1724 would provide the board all powers necessary to carry out its functions. As it relates to the BAC, it is unclear how LD 1724 would be implemented. Apart from certain jurisdictional questions which were addressed in separate testimony from the Department of Labor, LD 1724 does not specify which members of the BAC will be appointed to the Logging Dispute Resolution Board. It is unclear who will provide administrative services for the proposed board and from what budget allocation those services will be funded. Additionally, while LD 1724 indicates one party will be responsible for the cost of arbitration before the board, it does not define the method of board members' compensation. In particular, will board members be subject to a statutory per diem like the BAC or be free to set their own rates of compensation? Depending upon the answers to these questions, the BAC, through the Maine Labor Relations Board, may request a supplemental budget allocation to address the potential impact to administrative operations. And thank you for the opportunity to discuss this bill, and I will try to answer any questions you have.
Thank you so much. Do you have any questions from the committee? Seeing none, thank you so much for being here. If we have any more questions, we'll follow up for the work session.
Thank you.
Is there anyone left in the attendees portion who would like to testify on this bill? Please raise your hand. Seeing none, I'm going to close. Oh, wait, Senator Hickman. Oh, you're on.
Thank you, Madam Chair. Just for the work session, since Senator Guerin thought I was confused about a question that I asked of Ms. London earlier, it didn't really have anything to do with the size of her business, how an employer or an independent contractor works. But since you brought it up, in case I'm wrong, I wondered if Mr. Langland can bring to us anything from Maine law or federal law that would treat the size of the business around classifying workers as independent contractors and employers any differently. Because I've never seen that before, but that doesn't mean it's not there. So I'd like to know if that is the case. Thank you.
Absolutely, and duly noted. Any other questions for analysts before I close this? Seeing none, I'm going to close the public hearing on LD 1724. I just want to look to the committee. Does everyone have a 5-minute break, or do you want to jump through and keep going? Getting a lot of blank stares. So was that a yes on a break? Was that a no? Do thumbs up for break, thumbs down for no break?
Madam Chair, can we please have a break?
Yes, Senator. We're going to take
no break needed here.
Thank you.
5-minute break, especially to give the chair a chance to grab some coffee and water. So we'll be right back, folks. Okay, folks, I'm going to give everyone the 1 minute warning to start making their way back to their computers.
You just startled the heck out of me, Madam Chair.
I figured a nice voice was better than a bang of the gavel.
Madam Chair, someone in the chat asked what bill we were going on to next.
Yes, I was going to ask Representative Cuddy when he comes back, because I do know he has a time commitment at 2 o'clock, which hopefully there's still some good space between us and the 2 o'clock hour. But I did want to check with him about potentially going next. Representative LaRochelle, I also see that you're an attendee portion. If you have a time constraint as well, if you just want to let us know. Oh, Representative Cuddy is back. So Representative LaRochelle, I think we're going to go with Representative Cuddy's bill and then jump to yours. So seeing folks working their way back. Looks like we have a almost critical mass. Just need one more member to come back on camera, please. There we go. Okay, we're going to jump right in now. I'm going to open the public hearing on LD 177, an act to improve labor laws for workers in Maine. And I'm going to pass it over to our own Representative Cuddy to present his bill.
Thank you very much, Madam Chair. And the wind kicks up at the appropriate time, so my internet will probably drop off right in the middle of what I have to say, but hopefully we'll be able to get through it. So Senator Daughtry and members of the Joint Standing Committee on Labor and Housing, my name is Scott Cuddy and I live in Winterport. I represent House District 98, which is comprised of Frankfort, Winterport, Searsport, and Swanville. I'm here before you today to speak in favor of LD 177. I apologize for bringing a concept draft at this late stage of the session. I particularly apologize because although I have been working on an amendment, we got the information we needed for the amendment quite late, and so the amendment is not printed. So I'm going to describe the amendment to you and just give you the idea of what it is I'm trying to do. So over the years, Maine has adopted a real zeal for apprenticeship, and I fully understand this, as apprenticeship is the best way to learn most any trade or profession. The combination of class time with actual work experience is a time-honored one. I myself am a graduate of a 4-year apprenticeship in the IBEW, and because of this recognition of the value of apprenticeship, we have greatly increased the number of apprentices we are supporting. Sadly, we have not matched that in the amount we are giving to support that apprenticeship, and I'm talking about funding. I'm proposing adding $195,000 to the training reimbursement line for the Maine apprenticeship program. This will bring the total up to $200,000. Those among you who are quick-witted at math might realize that this means the state of Maine is currently only funding training reimbursement at $5,000 a year. If we value apprenticeship, then let's value them. $5,000 a year for thousands of apprentices is not valuing them. The bill will also require that the additional funds be used only for training reimbursement. So this money couldn't be used for overhead, for a new position in the program. It could only be used to reimburse programs that are training registered apprenticeships. Thank you for your time, and I welcome any questions that you may have.
Thank you so much. Do you have any questions from the committee? Representative Gehr.
Thank you, Madam Chair. And thanks for this bill, Representative Cuddy. As you know, I'm also a big fan of apprenticeships. And are these for so these are for apprenticeships that are registered with DOL? Would that be correct?
Yes, registered with the Maine Apprenticeship Program. We had a bill last session that was dealing with how the funds get dispersed, and you would have to be registered in the same kind of setup as that bill discussed.
Great, thank you.
Any other questions from the committee? I think we're going to let you off easy today, Representative Cuddy, but I'm sure we'll have plenty of questions to make up for it in the work session.
Yes, well, after yesterday, I wanted to bring a nice, short, quick bill.
Definitely get a gold star for that. Okay, we're going to move on. We only have one member of the public signed up to testify on this bill. So Jason Shedlock, I am porting you over. And if there's anyone else present in the attendee portion of the Zoom who had intended on testifying on this bill, please raise your hand. Not seeing anyone. Mr. Shedlock, the floor is yours.
It has been far too long, Senator. Thank you for having me. Good afternoon. I am still Jason J. Shedlock, Regional Organizer for Laborers International Union, President of the Maine State Building Construction Trades Council, Trustee and Executive Board Member of the Maine AFL-CIO and Southern Maine Labor Council, as well as serve on the Maine Apprenticeship Council and State Workforce Board. I appear before you in support of LD 177, an act to improve labor laws in Maine. Thank you to Representative Cuddy for his work in finding a straightforward solution to a growing need in our state. I would like to start out by sharing a bit of personal perspective. I've had the privilege to testify in front of many bodies of decision makers in my career: U.S. Congress, state houses, county commissions, city and town councils across the country. I always hope for and try for a unanimous vote up or down on behalf of working families. I also know that's a rarity. Committee members, I am confident that LD 177 is one of those unicorns, as they say. A bill where both sides of the aisle can agree that registered apprenticeship isn't a partisan issue, but a human issue. As I mentioned, I sit on the Maine Apprenticeship Council, honored to have been appointed by Governor Mills. On it, I approve union and non-union registered apprenticeships every week. The Maine Apprenticeship Office's excellent staff sends us a list of new applicants every Wednesday, in fact, for us to review. I'll get some tomorrow. And if they meet the standards set, we recommend approval. And if approved, these registered apprenticeships then qualify for state reimbursement for training their apprentices. And herein lies the issue that LD 177 is trying to solve. The state of Maine used to reimburse the program sponsor a small business training an apprentice, for example, up to $1,200 a year for the duration of their apprenticeship, typically between 2 and 4 years. Representative Cuddy's apprenticeship was 4 years. This defrays the significant investment the Business or Joint Apprenticeship Training Council puts forth to train up their new hire. A few years ago, that reimbursement rate inexplicably plummeted to a one-time $500 reimbursement for each apprentice. We were told that that was because of the proliferation of the number of registered apprentices, a victim of the program's success, perhaps. For whatever reason, the plain fact is that that token dollar amount is not nearly enough to help defray the costs of implementing an apprenticeship program for a small business or a JATC. Further, it does not match the tremendous focus that Governor Mills, Commissioner Fortman, and their highly professional staff has placed on this tried and true workforce development model. LD 177 is a true bipartisan step in the right direction to fix this issue so that all registered apprentices, union and non-union, in all fields, can access meaningful reimbursement rates in order to train Maine's workforce of the future. Thank you very much for your time this afternoon, and I stand ready to answer any questions that you might have. Thank you very much.
I have a question from Representative Gear.
Thank you, Madam Chair. Nice to see you again, Mr. Shedlock. Curious as to what proportion of the registered apprenticeships that are happening that this funding would cover.
All of them. As long as they're registered with the state, basically what we passed, well, let me back that up a little bit. What we passed last session was that as long as they meet a threshold of funding, I believe it was 1.25 of the Maine state minimum wage, they would 75% of the Maine apprenticeship program funding was reserved for programs that meet that start out at 1.25 the Maine minimum wage, and that top out at 1.75, that at least top out at a rate of 1.75. 75% of the funding is reserved for that, and 25% of the funding are reserved for the other programs. So basically what we're trying to do is urge the programs to at least start at a rate that learners can make a living on. And what we've seen because of that legislation is programs are bumping up their starting rate. It's doing exactly what we'd hoped that it would do. And as we see these programs come across our desks, the first question we ask is, what we've asked in the beginning was, do they meet the intent and the practicality of the law that we passed? And in the beginning, no, not really. Well, go back and ask them if they're willing to bump up their wage 5 cents, 7 cents, to start out. And they would go back and say, okay, we'll do that. And what that means is that the learners are then making a little bit of a higher wage to start. So the short answer is, when these reimbursements happen, that most, if not all learners will see it, will be able to get those reimbursements.
Great, thank you. That's good to hear.
Representative Bradstreet.
Thank you, Madam Chair, and thank you, Mr. Shedlock. Curious, how does one program get to be registered, and are there any unregistered programs in the state?
Thanks for the question, representatives. I'll take your first question first. So what the program would do is they would reach out to the Maine Department of Labor and work with their staff. They have a very highly skilled staff, technical assistance folks to walk them through the process. It is not an onerous process. There are very small companies, small businesses that the Maine Department of Labor staff will walk them through some paperwork to fill out, some benchmarks to meet. Basically, what has to happen is the learner has to have a set pathway so that they have an expectation of what they need to do in 6 months, a year, 18 months, and so forth in order to know what benchmarks they have to learn and then what wage that they will make in conjunction with those benchmarks. So that both the learner has an expectation and then the employer has an expectation of what they can expect from that individual, from that employee. So they work together. It's a partnership. So that's basically what happens. They work with the Department of Labor to come up with a program, and some of them are a little boilerplate. If you're depending on the industry, but some of them are customizable as well, obviously to the needs of the employer. So that's the answer to your first question. The second question is, if you're a registered program, that's how you would go through the process. If you have a non-registered apprenticeship, that's a job training program. That's a program where the learner might not necessarily know their pathway to get credentials and a set pathway to salary increases. I'm sure that employers have programs in place to do that. Of course, they're not necessarily going to get a stipend from the Maine Department of Labor if they're not registered with the Maine Department of Labor, and that program isn't vetted and approved by the Maine Department of Labor. So I'm sure that employers all around the state have things that employees need to learn in order to be on that job. That's job training in a sense, but that wouldn't qualify as a registered apprenticeship.
One more question, Madam Chair. I guess it's a yes. Okay, thank you. So you're a member of the board that reviews these, or how many members on that board? Can you tell me briefly how that's comprised?
So there's, I might say 11, maybe between 9 and 11 members on that board. Put me on the spot there. I can get you that list very easily. I'm sure your analysts can as well. That those members are appointed by the governor. Some of them, were appointed by the previous governor and reappointed. That's a rolling, list. And some of them they're reserved for certain classifications of representatives. There's business representatives, there's individual representatives, there's representatives from labor, representatives from women's groups. Basically in statute, it's to make sure that everyone from different constituent groups from around the state can be represented on this group, on this the Maine Apprenticeship Council.
Very good, thank you.
From Senator Guerin.
Thank you, Madam Chair. I have a question for you, Mr. Shedlock. What percentage of the expenditures have gone to labor unions?
That's a good question. I can say that most registered apprenticeships are not union registered apprenticeships in the state of Maine. I don't know the amount of money that could be found in the Maine Apprenticeship Council's annual reports. As far as that's concerned, that's a Department of Labor question. I'm sure that they can answer that for you, or your analysts could get it. But most registered apprenticeships, if you look at their list on the website, are not union registered apprenticeships.
Thank you. Mr. Langland, is that something you could look at for me, please, before the work session?
I assume he's giving us a thumbs up in the chat for those watching on YouTube. I have a question as well, sort of building off of that, Mr. Shedlock, of, there's, the question of whether they're union or non-union, but more important for me is I'm wondering, what are the various aspects of professions and trades that it covers? And if you could just give like a quick sampling of like how many different career paths we're talking about.
My goodness. Yeah, I think, obviously, who I work for and what I do. I'm no stranger to this committee, but, we're talking about funeral morticians and funeral directors. We're talking about hairstylists. We're talking about certified nursing assistants. We're talking about construction workers. We're obviously talking about electricians and, career pathways that Representative Cuddy took. We're talking about, machinists and forestry workers, and it's the wide range. Yeah, there's clerical workers and accountant assistants, and I know I see that Mr. Langland put the council makeup in the chat. It's a wide range. So obviously, you're talking to somebody that represents my industry, but as we look at these things, we're all just as qualified to approve any of these, because we take a look at the standards. If they have a certain number of classroom hours, if they have a certain number of on-the-job training hours, I approve them. Now, do I get excited when a union apprenticeship comes across my desk? Of course I do. It's what I do. But I approve a non-union apprenticeship the same way. I give recommends approval. I send the email just the same. So, and it's a wide range, and it's interesting to see those come across. And we should be very proud in the state of Maine, not only to approve these types of projects, but to see the federal dollars coming in to fund pre-apprenticeship and apprenticeship projects, targeting people, traditionally underrepresented populations, women, people of color, and making sure that we're, training the workforce of the future in all sorts of these different industries.
Absolutely. And I think building off of Representative Bradstreet's question, a follow-up I have is, when you have a registered apprenticeship, you're getting that credential at the end. And can you talk about a little bit how that's recognized in other states? So say you're a student and you're here and you're training with, I'll use an example from my own Senate district. You're doing one of the registered apprenticeships with BIW and with General Dynamics. Is that a type of, thing that you can port, to other parts of the state? Not that we don't want anyone leaving. We want to try to keep them here, but, is that the type of, credential that, really does open the door wherever that student may go?
It is. And, a lot of times these registered apprenticeships, the benchmarks and the credentials that they earn are, they're widely recognized. I know obviously from our perspective, our, many of the certifications that you earn in these are, they're portable. So everyone recognizes them both in and out of state. We don't want to lose anybody, certainly not within your district, but within the state as well, right? We want to keep them here in Maine, and we want to bring people into Maine. So the short answer is yes, right? So when you're in a registered apprenticeship, oftentimes for us, it's registered in the state of Maine, but it's also registered with the United States Department of Labor, right? So, that's a broad, and there's a reason for that, right? So these are, for lack of a better term, blessed by these entities for a reason, right? They're quality programs. These are people that know what they're doing. They do this for a living. And I will say again, that the staff at the Maine Department of Labor eats, sleeps, and breathes these things. They commit their professional lives to these things, and they're very good at what they do. I've worked with them for years. on this, and we go back and forth on some things, have some really good conversations about, holding people accountable and trying to sort of raise the bar on these types of things. And they care about what they do, and they're very good at it.
Absolutely. One last question, and then apologies to the committee. I can talk about apprenticeships and career and technical education and any post-secondary work for way, way too long. This is my happy policy spot. But putting my small business owner hat on, just sort of thinking, the bill before us, would this really, how much do you think this could change the opportunity for, small businesses like myself with brewing, or thinking of, Senator Guerin and everything, her company does of, getting qualified people to be able to do restaurant installs. Like for the two of us, how could something like this potentially change our access to workforce with this bill?
Well, that's a good question. And I think this is partially, what's exciting about this is, a one-time $500 reimbursement for you to develop an apprenticeship program. And again, you have the technical assistance, you have that free help, quote unquote, although it's paid for obviously by the taxpayers. So, our Representative Bradstreet and Guerin will probably say that taxpayer money obviously is going to good use, and I hope that it is. But that technical assistance, obviously there's a dollar amount that is attached to that. But for $500 a one time, for a small business whose owner, and I know you both know it well, is turning around, and who is that small business, right? The amount of time that you have to invest in developing a program, overseeing that individual, training them, making sure that they're meeting those benchmarks and moving forward. That's really not, that amount of money is, I used it in my testimony, it's a token amount of money. And, no one is necessarily to blame per se because of that, but I will say that it's just not really helpful to increase that to what it used to be a couple of years ago. We're not really, and obviously if the budget is such that it can go higher than that, that would be great. But if it increases to $1,200 per student per year, now we're talking, right? You're able to use that money to perhaps, move some responsibilities around to folks in your small business to oversee some, that individual a little bit, some hours a week, to help develop the program, to help them monitor them as they meet their benchmarks, and take some of the load off of some of your employees. So it makes it worth it to be able to train that individual who's then going to turn around and be one of your full-fledged employees. So it's an investment, I think, that the state should make and then turn around. And then, obviously that's going to pay you back manyfold. So I think it's a good use of taxpayer dollars. It's a good resource for our small businesses and all businesses, I think. And obviously it's a good resource for us in the union environment as well. But I think it's a win-win for us across every sector.
Definitely. Thank you so much. Senator Guerin, do you hand up for another question, or is that from before? Yes, no, maybe. Delay of the interwebs. Is there anyone else on the committee who has any other questions for Mr. Shedlock at this time? Seeing none, thank you so much for your patience and for your willingness to answer all of our questions. If there's anyone else in the attendee portion here to testify on this bill, please raise your hand. Okay, seeing none, Representative Cuddy, you may have a record for shortest bill of the session thus far, but I'm going to close the work session on close the public hearing on LD 177, and I look forward to the work session. And with that, I'm going to port over Representative LaRochelle to get ready for our next bill. And I do want to make sure that folks do see in the prior bill the information that Mr. Langland did put in the chat. Can't wait to look through that later on. Okay. And with that, I'm going to open the public hearing on LD 2006, an act to improve the low-income home energy assistance program. And I'm going to turn it over to Representative LaRochelle, who will hopefully be far more eloquent than I am right now.
I wouldn't count on it, but I will try. Good morning or afternoon, I guess. Senator Daughtry, Representative Sylvester, and esteemed colleagues of the Labor and Housing Committee. I'm Representative Reagan LaRochelle, and I represent my hometown district, 86, which is part of Augusta. I'm here today to present LD 2006, an act to improve the low-income home energy assistance program. Each one of us are in the privileged position of being constituents, advocates at the State House. And as a new legislature, one of the issues I've been hearing most about are the rapidly rising energy prices. Even prior to the events happening across the globe, Mainers saw the price of home heating fuel increase dramatically over the past year. In February, heating fuel per gallon were $2.42. Last month in February 2022, they were $3.75 a gallon, which is over $1.30 per gallon more than last year at this time. Let's keep in mind that these are average statewide prices. So in some parts of the state, the cost per gallon of home heating fuel is now gas prices are rising to levels we have not seen in over a decade, and our neighbors are feeling the financial crunch. This is particularly on those on fixed incomes, our seniors, young families, and our most vulnerable citizens. Recently, there have been reports that Maine Housing's Home Energy Assistance Program, or HEAP, has more money in it than it ever has before. And while this is great news, people are unable to receive these funds in a timely manner due to significant delays in processing and approving applications. This bill aims to increase the ease of access to the existing assistance funds by providing support to Maine Housing and the CAP agencies who administer the funds to improve their processes. Specifically, LD 2006 directs Maine Housing to establish the HEAP Administrative Efficiency Fund. The provided funds would be used for the purposes of increasing the capacity to accept and process applications in a timely manner for the current heating season. And I recognize that spring is on its way and the use of home heating fuel will soon decrease. However, as of today and the next few weeks, this will still remain a critical concern for the people we represent, which is why this bill is an emergency. Additionally, the funds we allocate to the Administrative Efficiency Fund can be used for providing resources to establish long-term systems to efficiently process HEAP applications in future years. The bill also directs Maine Housing to convene a working group to investigate ways to improve and increase the efficiency of the HEAP program, and explicitly states the working group must include one or more individuals who have used the program. I believe it's crucial that we include these perspectives in the conversation and work to build a system that directly addresses the primary obstacles that we are facing. I have learned quickly in my first few months as a legislator that I cannot issue my constituents quickly or as completely alike. Your support, I hope this bill can first go winter and aid in the creation of a better system where Mainers across the state do not have to wait weeks or months for their HEAP application to be approved. And Senator, I don't know how much time I have left, but I just will say quickly.
Oh, Representative LaRochelle, you got muted there for a split second.
Oh, can you hear me okay now? Okay, great.
Oh, Strange, you got muted again. One trick you can do, and a good trick for the whole committee, is if you just keep the space bar down, hold it down while you're talking, it'll keep you.
That would be helpful. Let's see if I can make it through it. What I quickly wanted to say was, as a live example, a woman contacted me this morning that said she applied for funding in November. She had her intake application on February 12th, or her intake appointment, where she had all of her materials, and they processed her. And as of today, which is almost a month later, she's still waiting for her decision. She has a balance with her oil company and is trying to decide whether to pay down the debt out of pocket or address other bills that she has at this point. So these are real, people are feeling these issues right now, and they're real. And I think that this would really just help to address a problem in a real concrete way. So thank you.
Of course, and thank you so much, Representative LaRochelle. Is this your first time being in front of our committee?
I think it is, yes.
Well, welcome. And
thank you.
Chair. I have a question up first from Representative Warren.
Thank you very much. I wanted to ask, thank you very much for bringing this bill forward. And I appreciate your testimony. This may be a question for you. It may be for someone coming after you. So please just, let me know that. I know that the way that our CAP programs work, they're really resourceful and really consider things like, I know programming around the whole family, or just have a really intersectional, thoughtful approach, kind of in a very practical way about how to use their resources. And I'm wondering, can you talk about in that this bill is focused on funding and giving the resources for programs that already work and are already good, but just need to be ramped up? How does this allow for that? Kind of, I guess, how they use coupling of services, or kind of help someone with LIHEAP and then find that they can help them with something else as well. Maybe you're not the person to ask about that, but I'm just curious how that was done, who was consulted, and I really appreciate you bringing this bill forward and supporting such an important issue.
Thank you for that question. So I will admit that I am not the expert on the CAP programming and information that they may have available, but people who I have talked to have indicated that, the purpose of this is to figure out if there are some efficiencies that haven't been realized in terms of sharing information amongst different entities. Is there a faster way to figure out what someone's or validate someone's income and household size, and do they have to keep going through that process over and over again if it's somewhere else, for example? I also know that there's no online application for this process, for this program. And I think, I think everyone who's involved in it understands that there are inefficiencies. And so I'm really hoping, we can give this to the work group who will be the experts and help them to, help facilitate solutions so that next winter and for the rest of this winter, we can kind of get this funding out, which we have. We have the funding, so let's get it to people who need it.
Absolutely, thank you.
Do you have any other questions from the committee at this time? Seeing none, thank you so much for being here to present your bill, Representative La Rochelle. And we're going to move on to testimony in favor. Up first, I have Megan Hannon, who I'm going to promote over to panelist, as well as Mara Pillsbury. I'm also going to pop Mara over, and she is on deck. And with that, Ms. Hannon, the floor is yours.
Thank you. I think I was stuck in transition there for a second. Good afternoon, Senator Daughtry and members of the Committee on Labor and Housing. I am Megan Hannon, Executive Director of Maine Community Action Partnership, and we support LD 2006. Maine Community Action Agencies are the local program operators and administrators for the Low-Income Home Energy Assistance Program, or HEAP. It's one of our oldest and largest programs, and community action agencies administer it across the country. In Maine, 9 of our 10 agencies have significant staff and infrastructure to serve just under 50,000 households a year, including seniors on fixed incomes and families with young children. We also use this program to introduce and feed our customers into other programs and services they're likely eligible for and may want to use, ensuring that we can wrap around the household's needs. HEAP is also a gateway program. Households who are HEAP customers may also be eligible for weatherization upgrade, heating upgrades, including moving from oil to electric heat pumps, and the electric low-income assistance program administered by electric companies. And as Representative Warren just mentioned, we braid funding from this with also our emergency rental program, our community service block grant programs, early Head Start, and others as appropriate and applicable to the household. LD 2006 proposes several changes or fixes to the current program, which are not new to those of us who have worked in it for many years. I'll just run a few of them. In Section 1, we absolutely agree that the HEAP benefit should not be considered income, and it's actually a federal law that it is not, so it's not exactly necessary in this. Section 2 proposes $2 million, and as has also been mentioned, the HEAP is actually pretty flush with funds this year. If the aim here is to support staff to administer the program, it is true that staffing has been an issue for the community action agencies, as it has been for Maine Housing, the energy suppliers, and most Maine businesses. In fact, in several cases, our agencies have processed emergency oil and gas applications just to find out the gas or oil supplier cannot get to the household anywhere from 5 days to 2 weeks. Unfortunately, more funding is not the solution for this. About the working group, we appreciate the inclusion of that to investigate current policies, procedures, and processes that each layer of program administration application undertakes. Maine Housing, of course, is beholden to Federal Department of Health and Human Services, Administration for Children and Families, Office of Community Services, Division of Energy Assistance. And I included the entire name so that you can easily see this is not a streamlined program to begin with. That said, there are areas that can be streamlined, and over the years we have discussed them in monthly meetings with Maine Housing and annual interested party meetings, the most recent of which was just on February 17th of this year. And I meant to attach an agenda to my testimony, but when I put it up earlier, I think today's Tuesday, I forgot to do that, but I do have that ready to go so that you can see that. I completely agree in that work group that including HEAP customers in the discussions of how to improve the programs is essential. The committee might also be interested, 30 seconds.
You're at time, so if you don't mind wrapping up, that'd be great. Thank you.
In 2019, Maine Housing did hire Re-Engine Consulting for services to perform a lean analysis of HEAP process. I have also included more information on that in my written testimony. So thank you very much for your time.
Thank you so much. Pardon me there. I have questions from the committee from Representative Warren, followed by Representative Bradstreet, and I think I'm going to sneeze again.
Oh, bless you. And thank you very much. And thank you very much for your testimony. I am really curious. I hope it feels relevant to what you're talking about, that whether there's a, I know that at the federal level, I think it's Senator Collins' bill, or it was in the last Congress, to kind of take off some of the red tape to allow further integration of services in this really innovative, important way that I understand the CAP programs do. And then on the other hand, I know there's just this massive longstanding labor shortage, and maybe certain resources shortages are limitations. But outside of those two things, you mentioned that unfortunately sometimes money is not, or funding in the immediate is not the primary issue. But I guess maybe I'm wondering more around the working group. Do you have any understanding or bigger picture perspective that you could give from your experience about where are the interventions that are places where we really need to dig in to make a difference in supporting the CAP programs from this state level? I hope that my understanding wasn't ignorant, but please correct me where I'm wrong. And thank you for the important work you do and coming forward today on this.
Yeah, I'm happy to. There are some things that have also been suggested. You have a work session this afternoon around the electronic application. And so that's something that I understand will be happening for next year. We've also talked about categorical eligibility. So when people are already have proven their income to LBHS, that we can take that as proof that they're also eligible for the HEAP program and the others that I talked about that fall under that. I think, as I said, we went through a lean procedure just a few years ago, and there were several things that were identified there, some of which have come through, some of which have not. This year, they did implement something so that if you've been a HEAP customer for the past, 1 year, let alone 5, 6, 10 years, that you don't have to go through the entire thing from scratch as though you're a brand new customer, that it's a shorter thing. And that's, we've been talking about that for a long time. So we are putting other things into place, and I hope that that will help to streamline it. Unfortunately, this year we are like everybody. We're not finding the staff that we had, or staff are out sick. And as I said, even when we have everything we need, we're giving some money to oil dealer X, and they say, "Oh, that's great, but I don't have a driver for another 5 days or another 2 weeks." So it is as everything is right now, just backed up from soup to nuts. Does that answer all of your question, Representative?
Yeah, I know I really threw a lot at you, but it absolutely did. I did have one follow-up question, if that's okay. Thank you very much. Is having to do with streamlining of services and putting things online where possible. Do you have a sense of any ongoing issues there that you think would be important as part of this working group, things like maybe privacy concerns or building trust with impacted communities, or issues around, I guess, how many people really are able to benefit from internet service. Do you have a sense from your clients or potential clients that would be positively impacted by those changes? Would that be something that you think this working group could be a part of addressing or considering, or maybe that's a little far afield or not as directly related, but I appreciate you bringing those things up. So I am curious, and hope you can indulge the question.
And we have a good, 2 years of data from the emergency rental program that is entirely online applications. And we know that there are people who don't have good internet. We've had the wind today, so we've all been through kind of coming in and out today. And that's why we have people who you can call. I mean, I myself, people have called because my phone number is the one that's on the website for the rental program. And I could sit here and type in somebody's thing for them if they're not able to, or they're not comfortable with it. This isn't something where they have to give over their, credit card or something like that, but still people don't always like to put their personal information on the web anywhere. Our software is absolutely HIPAA approved so that their personal information is as safe as any other online database is. I do know that especially, with the rental program, Maine Housing has also contracted a couple of ethnically based and run community organizations, so that for those communities, they have somebody trusted to go to, somebody that they know speaks the right language, can really help them go through the entire application process. And that may be possible also for HEAP in the near future. I do not know exactly. I'm assuming that Mr. Jorgensen from Maine Housing is in line somewhere and is going to be addressing this. But there are things like that we have done, and I hope do more of, to make sure that everyone has access to the programs and we're not leaving people out inadvertently.
Thank you so much. I have a question from Representative Bradstreet.
Thank you, Madam Chair. Thank you for being here. Actually, you just answered a couple of questions I had regarding potential confidentiality issues, so I think that's well addressed. Did I hear you say that maybe when it comes to funding, maybe we don't need $2 million from the general fund, but the Maine Housing may already have in-house funds to cover this? That's one question. And secondly, it seems to me like you have a pretty good idea of what needs to be done. Do you just need legislation to enable you to do that? Or is this, you already pretty well have a mapped out between your organization and Maine Housing as to what needs to be done?
On the first, I'll let Maine Housing decide on that. There is a lot of federal funds now for HEAP. You probably remember just a few weeks ago, the governor used some of that funding for a $90 per household for electric bills to offset the electric bills, not exactly on this, but also around heating. TANF just did the same and gave everyone who has TANF a benefit, and I forget the exact number, but a benefit for heat as well. So this is certainly something that's high on everybody's priority list. As far as what the fixes are, I think over the years we have had a lot of good conversations about what some of the fixes are. We also know that there has been a history of people being very sensitive to fraud and abuse of this and any other program, and so finding the balance between not making 9 people not eligible for a program just because one may be trying to get something that they may or may not actually be eligible for has been ongoing. And I think, with the success of the rental program being much more open because of the pandemic and because really people are hurting and wanted to get the money out quickly, we might have had a change of that. But again, how the rules change and when they change is really up to the folks at Maine Housing and their work with the federal government, and they have a lot of rules for HEAP.
Thank you so much. Do I have any other questions from the committee? Seeing none, thank you for your time and patience this afternoon. Up next, we have Mara Pillsbury and Eric Jorgensen. You're on deck. I'm porting you over.
Thank you so much, Senator Daughtry and members of the Committee on Labor and Housing. It's a pleasure to be here with you this afternoon. My name is Maura Pillsbury, and I'm a policy analyst at the Maine Center for Economic Policy. And I'm here to testify in support of LD 2006, an act to improve the low-income home energy assistance program. LD 2006 would create and fund the Low-Income Home Energy Assistance Program Administrative Efficiency Fund, providing $2 million to the Maine State Housing Authority to increase capacity and timeliness for processing LIHEAP applications. In addition, LD 2006 would establish a working group to further examine the issue of how to improve the efficiency of LIHEAP administration, specifically wait times for application appointments and the time required to approve applications. The bill also establishes that home energy assistance is not considered income for taxation or program eligibility purposes. Applicants to LIHEAP face significant administrative hurdles to receiving benefits, as you've already heard this afternoon, including long wait times for appointments and application approvals due to staffing shortages and the need to modernize the application process. Although adequate LIHEAP funding is available, these program backups are leaving vulnerable Mainers without heating assistance. We know that many low-income families are struggling to cover their basic household expenses, particularly during this cold winter. The U.S. Census Bureau's most recent survey found that 78% of Maine households with annual incomes below $50,000 had difficulty paying for usual household expenses in the last week, and more than 1 in 5 said it was very difficult. This comes as the cost of heating fuel has dramatically increased. We would also encourage the proposed working group to examine how LIHEAP could reach more eligible Mainers. According to the National Energy and Utility Affordability Coalition, only 21% of the total eligible population in Maine received LIHEAP in 2020. We applaud Representative LaRochelle for putting forward this bill and urge the legislature to minimize administrative hurdles to enrollment in the LIHEAP program and address excessively long wait times for assistance by passing LD 2006. Thank you for your time, and I would be happy to answer any questions.
Thank you so much. Do you have any questions from the committee at this time? Seeing none, thank you for your time and your patience this afternoon, not morning, and for being here.
Thank you.
Up next, we have Eric Jorgensen. And it's a lot earlier time to testify than last night. So congratulations.
Thank you.
Might be one of our, I think you're our last person for the day.
I'm glad to bring up the rear on both occasions. So last night was a late one. Senator Daughtry, Representative Sylvester, esteemed members of the Joint Standing Committee on Labor and Housing. I'm Eric Jorgensen. I'm from the Maine State Housing Authority. I'm testifying today in support of this bill, LD 2006, a bill that proposes to provide funding to help with the administration of the HEAP program. HEAP is the Maine version of LIHEAP, and each year it serves more than 30,000 households in Maine. We agree with Representative LaRochelle that this program currently has and has historically had some challenges around wait times. The program in Maine is delivered through the CAAs, the Community Action Agencies, and our CAA partners, as you've heard, have worked very hard on this and other programs, but they've been extremely stressed by staffing levels and COVID absences. Some similar challenges have been faced by fuel vendors and service personnel. The system is totally stressed overall, and that's certainly contributed to issues you've heard about. But I would say that just the same, this program has been getting out over $700,000 every week in benefits to Maine households. The program is based in federal rules that specify that the greatest benefit must go to the households with the lowest income and the highest energy burden. National data suggests that the average limited incomes family energy burden is as much as 3 times that of other families. And determining this burden is a complex federal guideline process that is more involved than the eligibility calculations used by most other government benefit programs. It's not just based on income, but includes considerations around house size, heating equipment, and other factors. Once your eligibility is determined, your benefit is calculated and payment is sent to your heating dealer, where it's placed on account to be used to offset the cost of your next delivery of oil, gas, wood, or whatever you heat with. Unlike most states where most people get their heat from 1 or 2 large utilities, Maine, we deal with literally hundreds of fuel vendors each year, which adds further complexity. So it's not a cash benefit, but a credit you get on your account. And hopefully you'll have it in place at the start of the heating season. HEAP is not designed to be a program that you call to enroll in when you have an eighth of a tank of oil. We have an emergency fuel assistance program for that. We take that very seriously, of course, but that's not this program. And we will get you the oil as quickly as we can. All that said, we are very concerned about wait times for initial appointments. People need to enroll in the program annually. That's a federal regulation. And in some parts of the state, those waits are almost non-existent. But in other parts, as you've heard, you can end up with a queue that can take weeks to get through. In a reaction to that, we've recently made 2 mid-year course corrections in this very winter to ease some of these bottlenecks. We've expedited the renewal process for people on fixed incomes. We've also reformed the application process for another category of recipients, those who live in subsidized housing. And those are important reforms, and we look forward to assessing their effectiveness. As I noted last week in my testimony around 1966, we're working to extend those for next year. We also plan to add 2 more significant program reforms in the coming year around categorical eligibility and an online application. We expect both of those to smooth out the application process. We also continue to be in conversation with LBHS around data sharing, and that's more or less on hold while they redo their My Main Connection computer system. And I think while some of those changes can be done under our existing budget, others will come at a cost. So this funding could make a real difference. And I know I'm probably out of time, but I'll just, yes. I see Representative Rader. Then I could have more. I have more to say. It's in my testimony, but a little more about some of the strategies we're using right now.
Thank you. I have a question from Representative Rader.
Thank you, Madam Chair. Mr. Jorgensen, my question is, if you did have more time, what would you have told us?
Well, I would say that we would be happy to discuss these strategies and other possible approaches with the working group that the bill proposes to establish. I will say that we have an advisory group around our HEAP program that consists of people from the CAPS and other experts. We've already got this group. It meets monthly. And if this bill were to pass, we would likely use that group as a core and add some new members to it. I'd also just tell you that this year, as part of this, trying to solve some of these problems, we are doing some HEAP focus groups. We're doing them with a third party, so it's not us coming in and talking. It's people that are using the program, that have been using the program, and it's trying to figure out about, you know, how better to reach people, how to make the program, the application process easier. So I just want you to be very clear that these are very, very important issues to us. We don't want anyone to be cold, and it's been a real challenge this year, but we're working on it, and happy to answer any of your questions.
Thank you.
Thank you. Do I have any further questions from the committee? Representative Gear.
Thank you, Madam Chair. Hello, Mr. Jorgensen. Nice to see you again. Do you all at Maine Housing have an estimate of the number of HEAP applicants that are in a delayed state?
I don't know. That would depend on the different CAP agencies. I know we meet with them on a monthly basis. I don't know what that is at this very moment. It's, you know, like I say, I think it's in some parts of the state, there's no delay at all. In other parts of the state, you're pushed out a bit. And that's a problem for us. I know I was looking just anecdotally, I was looking at a job. I was looking at the job postings for one of the large CAP agencies in Southern Maine, TOA. And I think they had 75 open positions when I last looked at that particular agency. I mean, it's just, they're having a really difficult time like so many other organizations. And you know, I'm not trying to give them a pass on this, but I think that these are really serious problems they're trying to deal with and trying to deal with in the context of other programs too.
If we could just have for the work session, any estimates that you have and any causal analysis of what all the different factors are that are driving that would be helpful. Sure. Thank you.
Do you have any further questions for Representative Pebworth?
Thank you, Madam Chair. Thank you, Mr. Jorgensen, for being here.
Nice to be here.
There's obviously a need for more efficiency, or I see these problems as something that a more efficient system could help solve. So I guess my question is one, do you see that as well? And two, I know you're relatively new in this position. Do you see some low-hanging fruit? Should we be optimistic about passing this legislation and seeing some rapid improvement?
Well, I think it's not going to happen this heating season in all likelihood. Although I will say again, as I said in my testimony, we've made some mid-course corrections this year out of an immediate reaction. We needed to get some more things through. So it's some of the things that Megan talked about and I mentioned, this idea of helping people renew quickly who are already on fixed incomes. There's also a large percentage of people who live in subsidized housing who get a $21 benefit for HEAP. They're not in danger of getting cold, but they have we refer to them here as heat and eats. It's a program, it's a federal program that allows you to get an extra food stamp benefit if you qualify for HEAP. And so people it's a very small amount of money they get, but that allows them to benefit more from the food stamp program. That's another federal program, but those people aren't in danger of getting cold, so they get pushed out some too. So what it allows is, it allows the CAAs to actually move their schedules around, sort of like in your dentist office, where you have a certain amount of emergencies combined with people who are on regular sort of treatment schedules that are pushed out a few weeks or pushed out a while, on an annual basis, who's coming in when. So that's sort of a triage process that's been instituted this year that I think will help. And that should really, we're still waiting to see, the analysis on that. But I think that's something that's very important right now. So I think that's probably the lowest hanging fruit. We're exploring maybe expanding the pool of organizations that are able to deliver the program. That's another thing that we're looking at in some areas, because there's just not enough capacity. I think that's an area where this kind of funding could be very helpful if we were trying to figure out how to broaden that a little bit. That wouldn't be a wholesale expansion, but it would be able to maybe reach out to certain other communities that we're not reaching very well right now. So that would be something this funding could be used for. And I just think that we're constantly looking at this and trying to figure out how to get throughput better. I mean, I think the fact that person that Representative La Rochelle talked about, who's been waiting since November and then hasn't heard back, that's an unacceptable situation. And I know that I'm sure that the CAA that she's working with is working very hard on it, but we just got to figure out how to improve that kind of thing.
Thank you. I have to say too, it never occurred to me that the heating dealer is so broad, that there are so many heating dealers in Maine. And I really appreciate us not narrowing that people can only get funding if it's this type of heating system or this type of heating dealer.
No, it's very important. A lot of people heat with wood, or we've even got a couple of people who heat with coal. Amazing. Who knew? But it turns out that it's probably a secondary heating system, but people sometimes use their heat benefit to try to provide that extra bit of heat to provide real warmth in part of your house. Doesn't mean they're going to be freezing, but it means that it's a supplemental thing for some people. But we really, it's a surprisingly complicated landscape.
Thank you.
Do you have any other questions from the committee at this time? Seeing none, thank you so much, Mr. Jorgensen, for your testimony and your time this afternoon. Is there anyone left? I'm only seeing 2 people in the attendees portion. So if anyone's hoping to testify on this bill, raise your hand. Seeing none, do I have any questions from the committee for our analysts? We had a few things to get flagged. Any other information you'd like to make sure that Steve has for us? Seeing none, I'm going to close the public hearing on LD 2006. Thank you, everyone. With that does conclude our public hearings of the day, but we are supposed to have work sessions. They were supposed to have started 18 minutes ago. But I can see everyone has the same sort of Zoom fried need food brain look that I feel like I'm emitting out into the world right now. So I think we're going to take about half an hour lunch break, if that's amenable to everyone, and then we'll come back in for work sessions. I assume Senator Guerin and Representative Bradstreet, if everyone goes straight into their breakout rooms. Justin, if that's something we can do for caucuses, does that make sense?
Yes.
Sounds good.
If folks come back a little bit early from lunch, Justin, if you wouldn't mind popping people into their breakout room. So if people need more time to caucus, just let me know. And Steve?
Yeah, the only thing I was going to say is that we have to get into our other Zoom link because we